Good morning. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, January 17th at 9 a.m. This is our weekly business agenda, and we will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have 5 of 7 commissioners present.
Great. Welcome, everybody. Good to see everyone. We're attending this meeting virtually, as is normally the case. We have a full agenda ahead of us. I am going to insert a brief additional item next before commissioner comments, and that is to recognize Deputy Director Larson for an update on our cumulative impacts rulemaking and efforts along those lines.
Thank you, Chair Robbins, and thank you, Commissioners. I have a very brief presentation that I'd like to share with everyone. So give me one moment. And hopefully you're able to see that.
Yes.
All right. So as we have been discussing for some time now, staff at ECMC have been working on drafting rules to address our cumulative impacts rulemaking that is to be completed by April 28th of this year. So I wanted to give the commission and stakeholders and the public an update as to where we are with that. So bear with me. There we are. So just a reminder as to how we got here. Back in 2019 with Senate Bill 19181, we were directed to evaluate and address cumulative impacts in the course of our mission change rulemaking. We did do that. The commission directed us to begin collecting a great amount of data to be housed in our cumulative impacts database, and for operators to provide a cumulative impacts plan with all of their oil and gas development plans that came in for consideration before this commission. We also acknowledged in the course of that mission change rulemaking that a follow-on rulemaking was necessary to fully address cumulative impacts, and that this initial step we were taking was necessary to gather the data to inform that future rulemaking. So beginning last year in January, we did begin an effort to, again, have a conversation about cumulative impacts and start looking at a rulemaking. In that time period, we also had House Bill 23-1294, which was proposed and signed into law in June of last year. And House Bill 1294 directly specified that this commission would define cumulative impacts and conduct a rulemaking no later than April 28th of 24 to adopt a definition of cumulative impacts and to evaluate and address the cumulative impacts of oil and gas operations. So that is why we're here today. As I mentioned, we started actually listening and re-engaging with stakeholders about cumulative impacts in January of last year, January 23. And this slide just depicts the various outreach efforts and listening sessions, informational dockets, et cetera, that we have engaged in over the last year. And it culminated in December of 23 with 5 in-person meetings that we held in disproportionately impacted communities to receive feedback about cumulative impacts and what this commission and staff should be looking at as we are endeavoring to draft rules to address cumulative impacts. So the input that we received was incredibly helpful. We took back that input and have been incorporating it into the rules that staff have been drafting. We are able today to announce that we are putting out on our website draft straw dog rules. They'll be posted later this afternoon for the public to review and provide comment on. With the release of the rules, we're going to have a Google form, as I said, for the public to provide their feedback to us. That form for public comment will close on January the 29th. So it will be open for almost 2 weeks. And then we're going to come back to you, commissioners, on January 31st and ask for you to provide us feedback to the initial draft that we have posted. And then once we have that feedback, once we have the input from the public, we'll take all that into consideration. revise the rules as may be needed, and file the formal notice of rulemaking with the Secretary of State in very early February to formally kick off the rulemaking process. And from there, after February and the announcement, the filing of the notice of rulemaking, we'll then have a schedule published that will show when parties, if someone wishes to be a party, how they can participate, what the schedule for filings will be. We'll also ensure that we schedule 2 public comment sessions in April. One will be an evening public comment session, one will be during the day. And our rulemaking hearing itself will be the last week of April, April 22nd through the 26th. And for individuals who are, again, interested in finding the rules, we're going to post them, as I said, today on our website. It will be on the main page under news and notices. There will be a link there, and that link will be up through the end of January. And then you can also check to see the status of the rulemaking, check to see filings, etc. if you go to our hearings page and then click on the rulemaking tab. So that was all that I had. I just wanted to let everyone know where we are. And if there are any questions from commissioners, happy to take them.
Great, thanks for the update. I think everybody's excited to see the straw dog draft, and we appreciate you putting forward kind of a calendar for us that we can all understand how that's going to work, and it's all available on our website. Do commissioners have any questions at this point? All right, seeing none, self-evident. The fun is just about to begin, so thank you very much.
Thank you.
All right, commissioners, we now have commissioner comments. Does anybody have comments? Seeing no comments, we move to consent agenda. Does anyone have questions on consent? And if not, do we have a motion to approve consent?
So moved.
Second.
Motion and a second to approve consent agenda. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Consent is approved. We now will bring up docket 2212000371. This is a general administrative matter. I believe this is teed up for oral arguments. Commissioners, why don't we take a little less than 5 and let this thing get set up. Let's return at 9:12. All right, welcome back, commissioners, to the January 17th Energy and Carbon Management Commission hearing. We're taking up docket 2212000371, general administrative matter involving applicant Merrick and Whitby, and petitioner Verdad Resources. I see we have Mr. Brashala with us. Good morning.
Good morning, Mr. Chair.
All right, and then Mr. Reinerson, is that right?
Yes, sir, Reinerson.
Okay. It looks like we are set for oral argument. First, Mr. Reinerson, you've got 10 minutes. You can also reserve some of that 10 minutes for rebuttal if you desire. I'll be keeping track of the clock. Do you want me to let you know if you have time for rebuttal, or are you just planning on plowing through?
Well, thank you, Mr. Chair. I would like to reserve 3 minutes of my 10 for rebuttal.
Okay.
If you could flash when we're getting towards that 7-minute mark, I would appreciate that.
I'll do something like this. How's that?
Thank you.
All right. With no further procedural matters before us, we'll get going. Mr. Reinerson.
All right. Good morning, commissioners. Thank you for the opportunity to present today. I represent the applicants, David Myrick Jr., Kate Myrick, and Tina Woodby, who are individual owners of overriding royalty interests in a federal oil and gas lease. As you are aware from the briefing that has already been done in this matter, this is a payment of proceeds action considering the decision of the present operator over the lease, Verdad Resources, to withhold payment of overriding royalties to the applicants on the grounds that certain other working interest owners have chosen not to consent to the drilling of new wells in the spacing unit that encompasses the lease. Verdad's principal legal rationale for withholding payment of the applicant's overriding royalty interest is a 2017 order of this commission, order number 1-202, which I'll refer to as the Catamount decision in this argument today. The hearing officer in this consolidated application concluded in his recommended order that the Catamount decision was squarely on point and that, as argued by Verdad, it precluded any obligation to pay applicants their overriding royalties until the statutory cost recovery obligation of CRS 34-60-116-7A1 was completed. With all due respect to the hearing officer, this conclusion was an error. In the applicant's written exception, we have set forth three major arguments as to why the commission should set aside the hearing officer's recommendation. One, the present case is sufficiently factually distinguishable from Catamount to render that decision inapplicable to the current circumstances. Two, the 2018 amendments to section 116(7)(a)(1) have sufficiently altered the statute as to render the Catamount decision no longer applicable outside the narrow circumstances of that case. And three, that Catamount itself was incorrectly decided in the first instance and should be abrogated by this commission. Because of the limited time I have today and the relative complexity of the legal issues concerning the amendment of the statute, I'm going to focus in this oral argument solely on the first and last grounds for setting aside the hearing officer's recommended order, that the instant case is highly distinguishable from the facts of Catamount, and that Catamount itself was incorrectly decided and should be abrogated by the present commission. Considering the factual distinctions first, in Catamount, a working interest owner seeking to avoid the statutory rule that non-consenting working interest owners are not paid during the cost recovery period purported to carve out a disproportionately high overriding royalty interest from its own working interest. It then elected to go non-consent on its residual working interest and filed an application with this commission alleging its overriding royalties should be immediately paid without being subject to the statutory cost recovery of section 116(7)(a)(1). In ruling on those facts, the commission saw the faithless working interest owner's creation of the overriding royalty interest as an effort to circumvent the statutory payment scheme that would jeopardize the public policy objective to promote oil and gas development in the state. As no exception then existed in the Colorado Oil and Gas Conservation Act to allow the commission to address this scheme, unlike today per the amendments to the statute soon after the Catamount order, the commission in Catamount interpreted the then existing language of section 116(7)(a)(1) to work an approximation of justice. The Catamount Commission did so by concluding that the faithless working interest owner should not profit from its scheme to circumvent the cost recovery provision of the statute, as that would unduly shift the burden of oil and gas development to the consenting working interest owners, thereby potentially threatening future oil and gas development, which would have been contrary to public policy. The case here presents dramatically different facts. Applicants acquired their overriding royalty interest by assignments made to them in connection with the sale of the entire working interest in the lease from the successor of the original lease owner to a new operator, and years prior to any spacing or pooling orders covering the lease. In May 2017, subsequent to the applicant's acquisition of their overriding royalty interest, this commission created what is typically referred to as the Sonic Star Drilling and Spacing Unit, or Sonic Star DSU. The majority of the working interest in the leases covered by the Sonic Star DSU, including the lease at issue here, was eventually acquired by the petitioner, Verdad, by January 2022. Approximately 1 month after Verdad acquired its majority working interest on February 23, 2022, this commission entered order number 535-1369, pooling the interest in the Sonic Star DSU, including the lease that the applicants hold their overriding royalty interests in. None of the applicants here today has ever held a working interest in either the lease or any other part of the Sonic Star DSU, and there are no allegations that they had any control or influence over the decision of certain working interest owners to go non-consent in the wells at issue here. Applicants' overriding royalty interests were recorded in the public record years before Verdad acquired its working interest, or the lease was pooled, or any wells were drilled by Verdad as operator. Applicants have not modified or amended their overriding royalties at any point since acquiring them. While Verdad will presumably argue in response that the broad wording of Catamount's holding covers the applicants just as it covered the faithless working interest owner in Catamount, these undisputed factual differences plainly establish a basis for a more refined reading of the obligations of section 116(7)(a)(1) that can be harmonized. The applicants believe, and by way, I should add, with regard to Catamount, the Catamount order itself does not provide much of the background information about the faithless working interest owner in Catamount. That information is contained in the briefing that the parties filed in greater detail in the Catamount case. And I would urge the commissioners to review not just the Catamount order itself, but the accompanying briefing that contains those additional facts. The applicants believe this factual distinction should be sufficient in itself to support a ruling in their favor. However, if the commission concludes that the rule of Catamount is so broad as to reach even the applicant's circumstances here, then the applicants would respectfully urge the commission to abrogate Catamount as being contrary to Colorado law. The hearing officer in this matter lacked authority to abrogate Catamount, as he flagged in footnote 4 of his recommended order, but this commission has the power to correct that error. The Catamount order was never appealed to a court for review and affirmation in a published decision by such a court. Consequently, this commission retains the discretion to abrogate the earlier order. Here, I would direct the commission's attention to B&N Services Incorporated versus Public Utilities Commission 429 P2D 293, Pin Site 295, Colorado Supreme Court. Thank you. The plain language. Is that the 7 minutes, Mr. Robbins, or 1 minute left?
You're at 7 minutes.
All right. I will conclude my 7 minutes here and save further points for reply. Thank you.
Thank you very much. All right, Mr. Pershala, you now have 10 minutes of oral argument.
Thank you. Good morning, Mr. Chair, Commissioners. My name is Joe Pershala with Wellborn, Sullivan, Meck, and Tooley, and I represent Verdad Resources, the petitioner in this matter. The MIREC central theme has been bad facts make for bad law as the basis for asking the Commission to overturn its sound legal conclusion in Order 1202, that an override carved from a non-consenting statutorily pooled working interest is not entitled to be paid during cost recovery under the Colorado's pooling statute. This bad facts make bad law adage is entirely misplaced because the fundamental question before this commission is a legal question, one of statutory interpretation, which is insulated from the surrounding facts. The goal of statutory interpretation is to give effect to the legislature's intent, and the starting point is the plain language of the statute. Both the MIRECs and Verdad agree that the cost recovery provision is not ambiguous. Thus, the commission should only be looking at the Conservation Act read as a whole to give all parts of that act meaning and effect. It's only after completing the statutory interpretation that the commission should apply the law to the facts. That order of operations is important, since much is made in the MIREC's brief that Order 1202 was based on facts distinguishable from the present case. As shown in Order 1202 at paragraphs 12 through 14, the facts are simply not relevant to the legal question of whether an override on a non-consenting statutorily pooled working interest gets paid during cost recovery. And the facts should not intrude upon this commission's statutory interpretation. The MIRECs asked the commission to elevate and equate their override with a mineral owner's royalty. However, the MIRECs have not provided any authority that supports such a result. Order 1202, in that order, the commission delved into the fundamental difference between a mineral owner royalty, which is entitled to be paid during cost recovery, and that of an override. And that discussion warrants repeating today. A mineral owner royalty is part of the mineral estate. It's something that's reserved to the mineral owner in the oil and gas lease, which conveys to the lessee the right to drill and develop. So the royalty is tied to the minerals themselves. And it's uniformly accepted that the mineral owner royalty is free of cost of drilling and completing a well. There are, of course, other interests in mineral estate that are also free of cost, such as non-participating royalty interests and severed royalty interests. And those would also fall under the categories of royalties or other interests not obligated to be paying cost during cost recovery. But unlike these mineral royalty interests, an override is carved from, but remains part of, the oil and gas lessee's working interest derived from an oil and gas lease. I cite to you Greinberg versus Waltman, 946 Pacific 2nd, 473 at 476 Colorado Court of Appeals, 1996, and I quote, An overriding royalty interest is not a freestanding interest. It is carved out of and constitutes a part of the working interest and is limited in duration to the life of the leasehold interest, close quote. While an override is not required to pay costs of drilling and completion, the override is different from a mineral royalty in that it gets paid out of the working interest owner's share of production revenue. Thus, the overriding royalty payment is not tied to the actual minerals, it's tied to production revenue. And that's critical in terms of a well where you have a consenting and non-consenting statutorily pooled owner that have not paid their share of costs. And that's because the consenting owners must pay not only their share of costs, but they must also pay that non-consenting owner's share of costs. And the cost recovery provision is intended to allow those consenting owners who have taken the risk of drilling the well and paid more than their own share of costs to recover back those portions of costs attributable to that non-consenting working interest owners, plus the risk penalty, out of the non-consenting owner's share of production revenue. As held by Waltman, because the override is not a freestanding interest and remains part of that working interest owner's production revenue, under the cost recovery provision, the consenting owners are entitled to recover their costs from the entirety of the non-consenting working interest owner's share of revenue. To pay that override during cost recovery would treat it as a freestanding interest that is no longer part of the working interest owner's production revenue. And it would reduce the portion of the non-consenting owner's share of revenue from which the consenting owners are entitled to recover their costs. That would thus increase the cost recovery period and increase the risk that those consenting owners assumed when they drilled the well. Another critical characteristic of an override is that it has no executory rights. It is bound by the decision of the working interest owner, that is, whether to drill, to participate, to not participate, or even whether to release and extinguish the lease itself, thereby extinguishing the override entirely. Thus, overrides carry a lot of risk. And the MIRECs are asking the Commission to avoid all of that risk associated with their override and elevate their interest to the protected class of a mineral royalty so that they can get paid regardless of their lessee's decision to participate. But nothing in Colorado law or the Conservation Act supports that position. When the legislature wanted to put the overriding royalty on equal footing with the mineral royalty owner, it knew how to, and it did so. And I would cite to sections 3460-118, subsection 5 and subsection 6. But importantly, the legislature did not do so here in the cost recovery provision, neither when the provision was enacted, nor later as part of any amendment, not even the 2018 amendment. Even the Commission does not treat a mineral royalty and an overriding royalty on the same footing. In relation to pooling, under the notice requirements of Rule 504(b)(3), notice specifically excludes overriding royalties from receiving notice of a pooling application. And when we look at the pooling statute as a whole, clearly it's designed to protect mineral royalties, mineral interests in the structure, but it's not designed to provide similar protections to the working interest or the overrides. Broadly, the pooling statute affords leased mineral owners protection under the cost recovery provision, which entitles those mineral royalties to be paid during the cost recovery period. And as to unleased mineral owners, those are protected by statutory royalty should they elect not to lease or participate in a well. So when we look at the pooling statute as a whole, it makes no sense to read the term overriding royalty into the cost recovery provision and afford the overriding royalty the same protections as afforded to the mineral estate. And while the MIRECs avoid the 2018 amendment in their oral argument, they make a great deal of it in their briefing. They argue that it was done to address the factual circumstances of Order 1202. But for that to be true, we must presume that the legislature was fully aware of Order 1202 and the underlying facts, and that the legislature drafted the amendment to address those facts. But why then did the legislature simply add the term override immediately following the word royalty into the cost recovery provision? Why would the legislature again not include the term override in the amendment language itself? Notably, the amendment has two conditions that must be satisfied for payment of a mineral royalty: that the royalty is consistent with lease terms prevailing in the area, and it's not designed to avoid cost recovery. If the amendment was designed to address overrides, why does the amendment evaluate royalty based on lease terms in the prevailing area? A lease does not and cannot inform the quantum of an override, which is created from a separate instrument not included in the lease. Cite to Degenhardt versus Gold King Petroleum, 851 Pacific 2nd, 304, Colorado Court of Appeals, 1993. Thus, the first condition must be specific to mineral royalties and not relate to overrides. Now, the Myrics have argued that you can ignore that first condition, and all you need to look at is that second provision that it's not designed to avoid cost recovery. But that would require reading that clause in isolation. The plain language of the amendment uses the word and, not or, between the two conditions, such that both conditions must be satisfied and both relate back to the term royalty. Now, the Myrics have conceded that their position is not based on the term royalty, but the phrase or other interest not obligated to pay costs. The Myrics can't have it both ways. Either the amendment clearly relates, if the amendment clearly relates to the term royalty, a term which the Myrics concede does not include overriding royalties, then the amendment cannot apply to the term or other interest not obligated to pay costs. Thus, that amendment is immaterial and does not alter the Commission's original analysis in Order 1202. Even more, the term other interest not obligated to pay costs is read to include overriding royalties, such that that term can, actually, I'm going to stop there and just turn to some of the comments that Mr. Reinerson made. With respect to stare decisis, I would note that the B&M case holds that an agency need not follow a prior decision for licensing based on the facts, but it does not speak to the binding nature of a legal determination. And I'd also note that the Commission properly determined that statutory analysis that an override is not to be paid, and that determination in Order 1202 was not based on any policy decisions, which is only noted in the order to bolster the statutory analysis conclusion. And with that, we would ask that the Commission uphold Order 1202, deny the Myrick exception, and adopt the hearing officer's recommended order. Thank you very much.
Thank you, Mr. Pershala. That was right at 10 minutes. Appreciate the timeliness. Thank you for the argument. Mr. Reinerson, you have 3 minutes.
Thank you. Most immediately, while Mr. Pershala alleges that there's no authority for the proposition that Section 116(7)(a)(1) would include overriding royalty interests, this ignores a decision of the Colorado Supreme Court. Section 116(7)(a)(1) states that a, quote, royalty or other interest not obligated to pay any part of the cost thereof, unquote, is exempt from the cost recovery provisions of that subsection. Colorado law is clear that an overriding royalty interest is, quote, an interest severed out of the working interest or lessee's share of the oil, not to be charged with any of the cost or expense of development or operation, unquote. That is Hagood, H-A-G-O-O-D, v. Heckers, 513 P2D 208, Penn site 214, Colorado Supreme Court, 1973. We also have Garmin v. Conoco Incorporated, 886 P2D 652, see Penn sites 656 through 57 and 664 through 65, another Colorado Supreme Court decision from 1994, and also the concurrence of Justice Erickson, which, among other things, notes that an overriding royalty is first and foremost a royalty interest. Here, the argument that Verdad makes effectively rereads Section 116(7) to read a royalty or other interest not obligated to pay any part of the cost thereof, except overriding royalty interests. That is not what the statute states. The Catamount decision, to the extent that it made that implicit reading of the statute, is thus contrary to law and should be abrogated by the Commission. Verdad has also argued extensively that it would be not fair that an operator should bear the burden of a non-consenting working interest owner, but the applicants here see no grounds for distinguishing a non-consenting working interest ORI burden from its leasehold burden. This is both implicit in the amendment itself, as discussed in our written briefing. But to the extent that the obligation for an operator like Verdad to pay overriding royalty interest to third-party ORI owners like the applicants can be characterized as a burden, it is an appropriate burden for the operator to bear. The present situation arises only because of the forced pooling of the leases in the Sonic Star DSU, which activated the statutory cost recovery provisions of Section 116(7)(a)(1). Forced pooling is first and foremost an efficiency measure for the benefit of the operator. Having conscripted the overriding royalty owners into a framework that they, as non-working interest owners, have no control over, it is more than reasonable for the operator to carry the obligation of paying overriding royalty interest during the statutory cost recovery period, notwithstanding that some part of the working interest owners may have gone non-consent as well. The applicants therefore respectfully request that the commission reject the hearing officer's recommended order and enter a decision in favor of the applicants.
Thank you, Mr. Reinerson. We now have concluded oral argument. It's not normal, but we're not a normal panel. Does anyone have questions of either attorney? Commissioner Cross?
Thank you, Mr. Chair, and thank you both of you for your presentations today. I do want to ask a few clarifying questions. I'll start with Mr. Reinerson. One of the things that I want to make sure that I understand your exception is that it was an exception about the timing of the payment. And so what I want to make sure I get a clear understanding of from you is your client's concern the fact that they are not being paid at the same time as the consenting owners, or is your client's concern that you're not being paid, or that you're being charged indirectly a portion of what's being charged to the non-consenting, the same as the non-consenting working interest?
Thank you, Mr. Cross. My understanding of the situation is that this amount is not simply being delayed, but is not being paid at all. And I do not understand that Verdad has any intent to ever pay it. Thus, it is both a desire to have it paid immediately and also to confirm that it will be paid, in that it appears from the Myrick's perspective or the applicant's perspective that the costs of the cost recovery are being charged against their overriding royalty interest, not simply that payment is being delayed until after the cost recovery period, and then they will receive arrearages to cover the amounts they would have otherwise been entitled to during the recovery period.
Okay, and that is helpful. And the reason I ask is because one of the things that is a little confusing to me is in your argument, you cite to the Garmin case, indicating that this being the overriding royalty interest is carved out of the working interest. However, you're now saying that regardless of the non-consenting working interest, your clients should be getting paid now without any charge. So how is it that their interest is carved out, but still being treated as something completely separate from the non-consenting working interest?
It's being treated separately pursuant to the language of Section 116(7)(a), which simply refers to interests that do not bear costs. It does not specify a royalty or other interest not obligated to pay any part of the cost thereof. It does not, the statute does not distinguish interests that are carved out of interests that are obligated to pay costs. And given that the characterization of an overriding royalty interest is that it is an interest, quote, not to be charged with any of the cost or expense of development or operation for the Colorado Supreme Court, it logically falls within the scope of an other interest not obligated to pay any part of the cost thereof contained in Section 116(7)(a)(1). Thus, whether the overriding royalty interest is characterized as carved out of, as being reserved at the original level of the lease or carved out of a subsequent working interest, I think does not make a distinction for purposes of the statute.
And I'll get to that very last part in a minute, but one of the things that I want to try and make sure I understand here is, so you're saying because according to the Colorado Supreme Court, as you're looking at Garmin and as you're looking at Haygood case, you're saying that it is not having to share in the cost. But do those cases say anything about having to be paid at the same time? In other words, before the payout occurs?
No, I do not believe they say anything with regard to the
So
timing.
they are very specific about the cost aspect, but not specific about when the payment occurs.
That is an accurate statement of those cases, I believe.
Okay. And as I touch on the last part of what you just said, and that was, it kind of goes back to one of the fundamental questions I had about some of the differences in the undisputed fact allegations. You talked about the fact that the overriding royalty interest here was part of the original lease, and then later on the working interest was purchased. How does that change it? Are you trying to allege that this overriding royalty interest is not part of that working interest?
No, the argument here is simply for purposes of the factual distinction of the Catamount decision, rather than that this creates a purely legal distinction. In Catamount, you have a situation in which a working interest owner
And I'll stop there. I understand that part. I just want to make sure that you are still saying that this is carved out of the working interest of the non-consenting owner, correct?
That is correct to my understanding.
Okay. And something you didn't really touch upon on your oral argument here, but I want to address with respect to your briefing. Now, you talked about the legislature in 2018 going back and adding into 116 subsection 7. And you're saying that addresses the fact that the Catamount decision is irrelevant now. We don't have to look at that. How does the language that was added to the end of 116 section 7 change Catamount?
Well, as I said in my opening, Catamount worked an approximation of justice. The interpretation of the statute in Catamount, with all due respect to the commission that decided Catamount, represented a effort from a public policy standpoint to solve a problem, a loophole that existed in the law. The General Assembly had not contemplated the possibility of this kind of action by a working interest owner to subvert the cost recovery provision. The commission in Catamount thus reached the best result it could based on the language of the statute then existing to resolve that problem and avoid the wholesale undercutting of the statutory cost provision by these sorts of effectively self-dealing overriding royalty interests. Subsequent to Catamount, the General Assembly amended the language that adds the further qualification, but if and to the extent that the royalty is consistent with the lease terms prevailing in the area and is not designed to avoid the recovery of costs provided for in subsection 7B of this section. Thereby, effectively both codifying in part and overruling in part Catamount through that amendment. The amendment effectively undercut the public policy rationale that informed the Catamount decision. And you look like you have a question.
Yeah, and so that's the part that I want to understand. Completely understand trying to get to the fact that Catamount had some very unique facts and trying to do an end around. But what I'm curious about is if the legislature was to look at that Catamount case and say it was important enough to address through an amendment to the statutory provision, why did it not address any of the other parts of the Catamount case to say we should specify in here that overriding royalty interest need to be highlighted when that Catamount case did not specify that the overriding royalty interest need to be taken into account there?
I would say that the General Assembly did not address it because it considered that the overriding royalty situation was already resolved through the or other interest not obligated to pay any part of the cost thereof, part of it. The General Assembly is assumed to legislate with knowledge of the decisions of the Colorado courts, and thus it would be presumed to have knowledge of both Haygood and Garmin, which both preceded temporally the 2018 amendments when they made this revision to the statute. They did not have any need to explicitly call out overriding royalty interests in addition to royalties or other interests not obligated to pay any part of the cost thereof, when overriding royalty interests were already fully subsumed within the terms other interests not obligated to pay any part of the cost thereof.
So, and I'm going to move to Mr. Prashal in just a minute, but what I really want to understand there is you're saying the legislature looked at it and said the other royalty interest is already covered, already addresses the overriding royalty interest. They saw the Cottonmount case, they thought it was important to address the public policy piece and change that, but they didn't clarify or change anything in the language with respect to other royalty interests to go against the rest of what the Catamount case said, that overriding royalty interests need to be addressed.
I mean, I certainly agree that the 2018 amendment did not specifically call out overriding royalty interests. I concur with that.
Okay.
I think it would have been redundant for the General Assembly to do so, given the state of the law under Haygood and Garmin.
Okay. And Mr. Prashal, if I could ask you some questions as well. Going back to the initial question that I asked and Mr. Reinerson's response, he's indicated that his client's concern was that his clients are not being paid now and may not be paid at all. I want to pose the same question to you. Is this an issue where the payment is going to be made for the overriding royalty interest, but just not until payout is reached? Or is this a situation where, because it's carved out from the working interest, that they are essentially paying for the non-consenting working interest proportion as well, as because it's carved out from that?
Sure. Thank you for the question, Commissioner Cross. So I think it's important there's a distinction here with the there's several wells within the unit, some of which the Myrick interest overrides burden consenting working interest, and then they also burden non-consenting working interest. So on the consenting working interest, that override is being paid. On the non-consenting interest, that interest does not get paid until after payout. So once the consenting owners recover their share of costs plus the risk penalty from the non-consenting working interest share, which under the Waltman case holds that the override is part and parcel. It is not a separate freestanding interest. It is part and parcel of the working interest, and it only gets paid out of the revenue stream of that working interest. Once payout occurs, that override gets paid just as the working interest, that non-consenting working interest, would get paid.
So until such time, and I just want to make sure I understand that. So under you said it was the Wyatt case?
The Waltman case, Grindberg versus Waltman.
Okay. And so under that situation, what you're saying is that once it reaches production and once everybody's getting paid, they will then be paid their overriding royalty interest, which I believe here is 1.25%. Is it also going to cover the costs that were previously taken out? Or are you saying that because it was carved out from the non-consenting working interest, that's still indirectly being charged as a proportion of the payment?
I think what you're suggesting is that during the cost recovery period, you're asking whether that override on the non-consenting share, not on the consenting share, is being suspended and then would be released at the time of payout, versus would they just be paid on the override that burdens the non-consent interest on production after the payout period? Correct. It is paid on the production after the payout period. There is no money being held. They would not be entitled to monies being held in suspense during the cost recovery period on the portion of the override that is carved from and is part of the non-consenting working interest.
And how do you then address what's said in Garmin and Haygood, that an overriding royalty interest is free of expense of production?
Great question. There are a host of types of interests that are free of cost. There are, on the mineral side, there are the mineral owner royalty. As I mentioned, there are non-participating royalties. There are royalties, other assigned royalties in the mineral estate itself. On the working interest side, there's overriding royalties, there's production payments, there's net profit payments. Those also are free of cost. So under the Myrick's theory is that those other interests, net profit interest, production payments, just simply because they're free of cost, would be entitled to be paid during the cost recovery provision. A working interest owner, savvy working interest owner, could simply just carve themselves an override, a production payment, a net profit interest to itself, to affiliated entities, and essentially disperse that non-consenting working interest among a variety of different interests that, under the Myrick's theory, would all be entitled to be paid during the cost recovery provision, reducing the portion of the working interest revenue from which the consenting working interest owners are entitled to recover costs to near zero.
Which is what happened in Catamount.
Similar to what happened in Catamount, but nothing prevents that from happening today. And that could still be done using the Myrick's theory that working interests that don't pay costs, shares of the working interest that don't pay costs, still get to be paid during cost recovery period. That simply makes no sense. And I think what's also important here is that when we talk about what the legislature was intending in this idea that the legislature, when it amended the cost recovery provision in 2018, didn't feel like it needed to add the term overriding royalty because the legislature knew that it was already subsumed within or other interests not obligated to pay costs. That runs contrary to what the legislature has done in other parts of the Conservation Act. And I cited to section 3460-118, subsection 5 and 6, where when you look at the types of interests that are being specified there, you have royalty, you have overriding royalty, and then you have or other interests not obligated to pay costs. So the legislature clearly distinguishes overriding royalties when it wants to do so. And it did not do so in the cost recovery provision as it was originally drafted, as it's been amended several times, and certainly not again in the 2018 amendment.
Okay, and the last thing I want to try and touch on here is going back again to the statutory provision and what you call the cost recovery provision. In your briefing, you say that it's clear what the legislature intended by it, and you talk about the purpose of this cost recovery provision is to protect the mineral owner's royalty that is to be paid on the non-consenting working interest owner's lease. And you're citing a Utah case. Do you know of any cases in Colorado that specifically address this purpose, or why can you explain that the Utah case is also the purpose of the Colorado statute?
Certainly. There is not a lot of case law in Colorado on the purpose of the pooling provision. It's really so there was there's not a lot of Colorado case law that specifies that. Utah's pooling statute is very similar to Colorado's pooling statute. Very, very similar. So I think the citation to the Utah case is applicable here for purposes of what is the goal of the pooling statute. And I think that's very important in that the pooling statute is designed to protect the mineral rights, the mineral interest owners, as I noted in my oral argument. And there was also a comment that was made by Mr. Reinerson about pooling, that pooling is to benefit the operator. That's simply not what pooling is designed to do. Pooling is the protection of correlative rights. That pooling was enacted in order to offset the limitations that spacing created. So spacing limits the ability of owners within a spacing unit to drill their own well. So what pooling does, it says that everybody within that unit, while not everyone can drill their own well, that everyone gets to share in the production well. So that's the purpose of pooling. It's not to benefit the operator. It's actually to benefit all of the owners, all of the mineral interest owners in that unit. And so I just wanted to make that point, because it's this idea that pooling somehow is to the benefit of the operator, is to the benefit of her dad. That's just simply not the case. It's a way to allow development efficiently amongst all owners, and that all owners that participate are entitled to receive their share of production, and that those that choose not to participate, they have to wait until that well pays out. And in this situation is the Myrick's bargain for what they got. They got an overriding royalty interest. It has a lot of risk associated with it. There is now, if you take it out of the BLM lease context and just put this into a fee lease context, there is nothing that prevents a working interest owner from just simply terminating the lease, washing out the override, going back and getting a new lease from that mineral owner, and those overriding royalty interest owners would be out entirely. There's a lot of risk with an override, and this is one of them, that they don't get paid when their lessee decides not to participate in a well.
And then final question, again, going back to the amendments made in 2018. You talk about the intent of the statute is clear. And again, why didn't the legislature do anything to specify that this is referring to mineral owners? Or why didn't it try and define what the royalty interest or other interest was here? Is it simply because 118 shows that there's numerous different types of royalties, or why didn't they take the additional steps to try and define what this provision meant?
If I may just ask a clarifying question, is it that why did the legislature not add the word mineral in front of the word royalty?
So yeah, so if one of the key things here that both sides are talking about is the specific provision within the statute that says excluding royalty or other interest not obligated to pay any part of the cost thereof. Now, under Garmin, it says an overriding royalty interest is not supposed to be paying any part of the cost. But here you're saying the royalty interest talked about is the mineral owner, and then the other interest is the same type of other interest that's talked about in 118. But 118 also specifically talked about overriding royalty interest separately. So is your argument that they didn't take that extra step because 118 already handles that these are three different types of interests? Or I'm just curious why they didn't go back and change that if they felt it necessary to add on that public policy provision.
Sure. I think if you look at the language royalty, it's widely understood a royalty is created out of a lease. Right? So we know that interest is protected. And then the amendment actually further clarifies that when we're talking about the word royalty or other interests, we're talking about, with respect to lease, with respect to royalty, we're talking about a mineral royalty because they tied the conditions to evaluate whether that royalty should be paid to lease terms that are prevailing in the area. Lease terms only can inform a mineral royalty. They cannot inform an overriding royalty interest. An overriding royalty interest is created by a separate instrument by the lessee and a third party. Looking at a lease is not going to tell you anything about that override. So clearly the legislature is affirming that the term royalty is we're talking about a mineral interest. And I think when we go back to the provision or the term or other interest, again, we go back to 118.5 and 6, there's a list of interests there. And I noted that there's royalty, there's overriding royalty, there's also production payments listed in there. That's another interest that is free of cost. But under the theory that the Myrick's are advocating for, all of those free of cost interests that come out of that working interest should be paid during the cost recovery period. And as I explained earlier, that would greatly diminish the working interest revenue, that non-consenting working interest revenue from which the other owners are entitled to recover their costs, and then therefore may never recover their costs. if they,
And so just again, one last clarifying point to that. So in 118.6, it says by the owners of royalty, overriding royalty, production payment, and other such interests. So the fact that it says in other such interests, while in 116.7, it specifically notes royalty or other interest. Does it make a difference that it says or other such? Could overriding royalty not fit in part of that or other interest?
my initial thought, and in which subsection are you referring to, Commissioner Cross? Are you looking at 5 or 6?
So in 118, you mean?
Yes, please.
So in 118, I was looking, let me pull it back up here. Sorry, I've got two different screens.
And I'm pulling it up. Just give me one moment here.
I am looking at 6 is where it says other such interests. Because in 5 it says royalties, overriding royalties, and production payments. Not talking about other interests.
Right.
In 6 it says royalty, overriding royalty, production payment, and other such interests.
I think it's a
So
distinction.
I'm just curious about that other such interest. Would, if that's clearly saying that an overriding royalty is an interest. So I'm curious as to why in 116, other interests is not part, does not include an overriding royalty interest.
Well, I think if they wanted to specify overriding royalties, they would have done so. And I think that the fact that it says other such interests versus other interests, that's a distinction without a difference.
Okay. That's the only questions I have. Thank you, Mr. Chair.
Other commissioners with questions for either attorney? Commissioner Ackerman?
Thank you, Mr. Chair. I really appreciate Commissioner Cross's detailed questions there. They were very helpful for me. And I believe this was clarified, but I just wanted to be crystal clear on this point, Mr. Pershala, that what I inferred from that was that there is no intention by Verdad not to pay the MIREX ORRI. Verdad's stance is simply that those interests should be paid minus the risk penalty, just as other non-consenting interests once the cost recovery period is complete. Is that correct?
Pardon me, I'm just thinking through your words and making sure that I answer your question correctly. And again, distinguishing between the override on the consenting portion versus the non-consenting portion of the working interest. So we're paying on the consenting portion. On the non-consenting portion, it's that the working interest, the entirety of that non-consenting working interest, is that revenue from that non-consenting working interest is the pool from which the consenting owners are entitled to recover their proportionate share of the cost that they paid for that non-consenting working interest owner that would have otherwise paid. So that pool pays back the consenting owners. Once that pool has paid back those owners for that share of cost recovery period ends, and the overriding royalty that is burdening that non-consenting share, that would get paid.
Understood. Thank you. That was helpful. That's it for me, Mr. Chair.
Further questions? All right. Thank you to the attorneys for the oral argument. We can move them off the panel at this point. And commissioners, I think we've got one of two decision items before us. One is, are we comfortable moving into deliberations right now? Or are we a little more comfortable taking this matter under advisement and thinking about it a bit, reading the briefs again, and then coming back and making a decision at a later date? Either option is available to us. Commissioner Cross, since you had most questions, do you want to weigh in on whether you feel comfortable moving into deliberations? or would you rather take a little time?
I think I feel comfortable with how I feel about the case. I would appreciate some time to put it into words. But I'd be interested to see how my other commissioners feel.
Commissioner Messner, you raised your hand.
Thank you, Mr. Chair. I would appreciate some additional time to review the briefings and be able to put some thoughts down prior to deliberation.
Very good. Let's continue this matter for a week, and we will take it up on deliberations next Wednesday, whatever day that may be. I'm not sure. Thank you to the attorneys. We'll anticipate having you back to listen to deliberations next Wednesday.
Thank you, commissioners.
Thank you, commissioners.
All right, let's take a short 10-minute break before we take up the next matter, which is docket 230800257, Bonanza Creek Energy Operating Company, OGDP. We'll return at 10:15. If we could get the witnesses and the attorneys lined up, that would be great. All right, welcome back, commissioners. Welcome back to our folks listening in. We're taking up docket 230800257. Well, this is a oil and gas development plan for Bonanza Creek Energy Operating Company. It is entitled the North Platte 13-24-25 OGDP. First up is Ms. Holliday from Weld County.
Good morning. Morning, commissioners, and thank you for the opportunity to speak with you today regarding Weld County's 1041 Wogula process on the Bonanza Creek Operating Company North Platte 13. Hold on, I think I had that number wrong. It would be the F36 pad. Weld County's Oil and Gas Energy Department held the pre-application meeting for the state North Platte Federal F36 pad on March 1st, 2023, at which time several alternative sites were discussed. Attendees included Weld County staff, Bonanza Creek staff, ECMC, and CPW. The initial 1041 Wogula application was received on May 12th of 2023. There are no building units within 1 mile of this location, although Weld County did send notice of our hearing to 2 individual property owners. Weld County did not receive any public comments on this application and did not receive any requests to participate in the hearing. Weld County also engages various referral agencies for feedback. Nothing of conflict or concern was presented by these referral agencies. The 1041 Wogula hearing was held on August the 10th of 2023, at which time Weld staff recommended a continuance to September the 7th of 2023 to allow Bonanza Creek adequate time to review and execute the outstanding road maintenance agreement. On September the 7th of 2023, the 1041 Wogula hearing officer considered testimony, found the application to be compliant with Weld County Code, and ultimately approved the permit. The final order was recorded with the Weld County Clerk and Recorder on September 11th of 2023 and published in the Greeley Tribune on September 15th of 2023, creating a vested property right for this permit. 2A comments were submitted to the ECMC on December the 4th of 2023 and are included in the director's recommendation. From a land use perspective, this is a good location as it's close to other oil and gas development. Weld County is in agreement with the director's recommendation and supports approval of this permit. And this concludes the comments I have prepared for this case. I'd be happy to answer any questions.
Great. Thank you. I'm trying to make sure that we're hearing the right one. I have the subject matter as the North Platte 13-24-25. You named it something different. I just want to make sure that we're talking apples to apples.
So what I believe the conflict there is that their oil and gas development plan is the North Platte 13-24-25, and they have the individual location identified as the Fed F36.
Okay, that's fine. Just want to clarify the record. Appreciate that, Ms. Holliday. Are there any questions from commissioners? All right, seeing no questions, take it back. We got a question. Commissioner Ackerman.
Sorry, Mr. Chair, a little slow on the trigger there. I apologize. Just a couple of clarifying questions. My understanding is that fluids are going to be transported via pipeline, but they're going to be transported to the state North Platte CPF facility and then held in tanks potentially there. Can you talk about what happens from that point?
I would actually have to look further into that. But I can look into that and get back to you.
Okay.
Perhaps that's a question for the applicant as well.
Oh, I'm sorry. I got distracted there, Mr. Chair. I thought Ms. Holliday was representing the applicant. I apologize, Ms. Holliday.
Yeah.
Okay.
Okay.
I'll handle that.
Great.
And certainly don't expect you to answer that. Thanks, Ms. Holliday.
Okay.
Okay, with that, we would turn to the applicant, Mr. McGee. Do you have witnesses for us today that need to be sworn in?
Yes, we do, Mr. Chair. I believe they should be on the screen now.
Ms. Mercer, if you'd like to take care of swearing in witnesses. Commissioner Cross has a question before we jump the gun.
I think we may have lost Commissioner McGowan.
No, she's there. She just was unvideoed because she's
Having breakfast.
All right, well, thank you, Mr. Chair. I will go ahead and get the witnesses sworn in. Good morning to the panelists. We'll go one at a time, and I'll just ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Annable.
My name is Jeff Annable, and I swear to tell the truth.
Thank you. Mr. Roush.
My name is Caleb Roush, and I swear to tell the truth.
Thank you. Mr. Miller.
My name is Stephen Miller, and I swear to tell the truth.
Thank you very much. Is there an additional panelist? I see a box with the name Rodriguez, but I do not see the face.
Yes, I believe he's having technical difficulties. He was mentioning earlier that Santiago Rodriguez. Are you able to turn on your screen, Santiago? Or your camera?
One, I can see everybody. Can you hear me?
We can hear you, sir. So we can just take you at your word that you're raising your right hand. If you could raise your right hand, state your name, and that you swear to tell the truth.
Rodriguez, and I swear to tell the truth.
Thank you.
I believe that is everybody now.
all right. We are ready for your presentation.
All right, Jeff, do you want to start the slides?
Sorry, Ryan, I actually thought you were going to handle that. I can pull them up.
I apologize.
All right, can you all see my screen?
Yes.
Okay, thank you.
All right. Well, good morning. My name is Ryan McKee. I'm a shareholder with Beatty & Wozniak, and I'm here today on behalf of Bonanza Creek Energy Operating Company, LLC, a subsidiary of Civitas Resources, in docket number 230-800-257, being an application to approve the North Platte 13-24-25 Oil and Gas Development Plan. First off, we'd like to thank the director and staff for their diligent review and work throughout this process. We truly appreciate all their hard work. Now, I would like to provide you with a brief overview and some of the highlights of this OGDP, and then hand it off to Jeff Annable for a short presentation regarding the details of the North Platte OGDP. Additionally, we have several subject matter experts with us from Bonanza Creek to answer any questions you may have following today's presentation. The North Platte 13-24-25 OGDP totals approximately 1,130 acres, which includes a 960-acre drilling and spacing unit and a 480-acre wellbore spacing unit, with both the DSU and the WSU targeting the Niobrara Formation. This OGDP contains one existing oil and gas location that is located within a portion of the northwest of Section 36, Township 5 North, Range 63 West, being the State North Platte Fed F36 pad. The F36 pad is an existing oil and gas location currently approved for the development of up to 7 wells. There are currently 7 wells that have been drilled from this location, and these wells will not be included in the North Platte OGDP. The North Platte OGDP requests approval for the state North Platte Fed F-36 pad to be amended to allow for the drilling of an additional 8 wells from this location, with 7 wells developing the proposed 960-acre DSU and 1 well developing the proposed 480-acre WSU. As Ms. Holliday mentioned, the state North Platte Fed F-36 pad is located within Weld County, which has approved the siting for this location, and there are no proximate local governments. Bonanza Creek's presentation today, along with the evidence in the record, demonstrates the North Platte OGDP allows for minimal mineral development in a manner that avoids, minimizes, and mitigates impacts to the public, the environment, and wildlife. A few significant highlights of this OGDP include the utilization and expanding of an existing oil and gas location to reduce the required new surface disturbances, which helps to minimize surface disturbance impacts. The state North Platte Fed F-36 pad avoids all residential building units, high occupancy building units, high priority habitat, disproportionately impacted communities, schools and childcare facilities, floodplains, public water systems, and wetland and riparian corridors. The location is greater than 4,100 feet from HPH and over 1 mile from all other receptors. An alternative location analysis was not required as part of this submittal, as no criteria were triggered. As part of this OGDP process, notice was provided to all interested parties as required by the rules. There were no comments or protests received for the North Platte OGDP, and the director has reviewed all elements of the North Platte 132425 OGDP and has recommended its approval pursuant to Rule 306B1, finding the North Platte OGDP complies with all requirements of the ECMC rules, and in the director's judgment, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. I will now hand this over to Mr. Annable for his short presentation.
Thank you, Ryan. Can everybody hear me good?
Yes.
Awesome. Thank you. Good morning, commissioners, and thank you for taking the time to hear our North Platte 13-24-25 OGDP. My name is Jeff Annable, Manager, Well and Location Permitting for Civitas Resources, parent company of Bonanza Creek Oil and Gas. Before you is an overview of the topics that we intend to cover during our presentation. I will be the sole presenter today, but here's a list of subject matter experts that are available for questions after the presentation. Now I will briefly give an overview of Bonanza Creek Energy Operating Company, LLC. Bonanza Creek is a wholly owned subsidiary of Civitas Resources, Inc. Civitas and its subsidiaries have had multiple OGDPs reviewed and approved by this commission. Bonanza Creek maintains all operating requirements and will be the operator of the State North Platte Fed F-36 pad, the only location proposed in this OGDP. Now I'd like to cover the procedural background of this OGDP and provide some general information. Before you is a list of procedural milestones. The North Platte 13-24-25 OGDP was filed on August 11th of 2023 and was deemed complete on November 6th. During technical review, the comment petition period closed with no comments or petitions filed. On January 8th, the director provided the recommendation of approval. Now I'd like to go over some general facts regarding the proposed North Platte OGDP. As you can see on the map, the State North Platte Fed F-36 pad is in the northwest of Section 36, Township 5 North, Range 63 West, and is an expansion of an existing location. Our nearby crossroads include Weld County Road 380 and 69. The only relevant local government is Weld County, and there are no proximate local governments. Our OGDP contains 1,130.75 acres, which includes a surface location, and will develop a 960-acre drilling and spacing unit with 7 new horizontal wells and a 480-acre single well drilling and spacing unit. There are no RBUs, high priority habitats, or disproportionately impacted communities within 2,000 feet of the working pad surface, and we do not trigger any ECMC ALA criteria. Now, I'd like to briefly cover the relevant local government process. First, I would like to thank Weld County staff for their thorough and efficient review. We kicked off the Weld County 1041 WOGA process with our pre-application consultation, during which ECMC staff were in attendance. There was no major concerns with the proposed development. Next, we had the hearing for the expanded location on September 7th, where no applications of intervention were filed, and the hearing officer granted approval. Next, I would like to cover the anticipated phases of development. If approved, Bonanza Creek anticipates beginning construction in February of 2024, followed by drilling in April and completions in August. Then flowback and production will commence in October, and finally interim reclamation in January of 2025. Now I'd like to cover our proposed cumulative impact mitigation and best management practices. During our previous hearings, we took some commissioner questions to heart regarding our cumulative impacts plan, and since this OGP was already scheduled for hearing, we wanted to make sure that this presentation outlines the cumulative impact mitigation measures and site-specific equipment that are proposed for this project. First, I would like to cover the cumulative impact benefits from the siting of the proposed expansion. The expanded pad will not have any RBUs within 1 mile, and the nearest HPH is greater than 4,100 feet. This is an expansion of existing pad that will utilize existing facilities and infrastructure, ultimately reducing impacts during the construction and midstream build-out. Next, I think a brief history is also relevant, as the originally planned location for this development was in an area surrounded by wetlands and located within HPH. After the Civitas merger, the development was reevaluated and moved to the State North Platte fed F36 pad, which is better development as it avoids HPH and potential wetlands, reduces cumulative impacts, and maximizes the minerals developed. Now I'd like to cover cumulative impact mitigations and reductions related to construction. As I've mentioned, this is an expansion of an existing location, which will reduce construction time and associated dust impacts. Additionally, we will deploy mud tracking devices and utilize fresh water as necessary to further reduce dust. And finally, avian surveys will be completed prior to the commencement of construction to confirm no conflicts, and the topsoil stockpiles will be constructed and stabilized to provide short and long-term stabilization. Now I'd like to cover drilling operations. We will be utilizing a Tier 2 dual fuel rig to drill these wells, since our Tier 4 equivalent drilling rig will be deployed to locations that are within CIC areas. I would also like to update the Commission that we are on schedule to convert our other rig to Tier 4 in August. In addition to the dual fuel rig, we will use a closed loop drilling system and pipe cleaning procedures when removing the drill string from the hole. Next, I would like to cover completion operations. I will cover the major highlights. A temporary lay-flat water line will be used to source water. A Tier 4 equivalent or better completion fleet will be utilized. Flowback will be routed through permanent production equipment, allowing gas to be controlled and sent down the pipeline or combusted with a 98% efficiency. And finally, I'd like to cover the production phase. The location will be upgraded with instrument air and a maintenance vessel in lieu of the maintenance tank that's currently on location. The oil, gas, water will be piped off location, and the location is currently and will remain tankless. And finally, the location will be equipped to shut in remotely. Next, I would like to go over the director's recommendation. So before you is a few technical highlights of the director's recommendation. CDPHE and CPW declined to consult on the proposed OGDP. There was one COA that was requested updated reference area photos to be taken during the 2024 season. I would like to agree on behalf of Bonanza to this COA. We were granted lesser area impact exemptions for noise and light mitigation plans. And finally, I would like to thank Director Murphy and the ECMC staff for their diligent and thorough evaluation and preparation of the conditional director's recommendation of approval. Now, I'd like to hand the presentation back over to Ryan to close out. And thank you, commissioners, for your time.
This marks the final slide in Bonanza Creek's presentation today and represents a final overview of how the North Platte 13-24-25 OGDP avoids, minimizes, and mitigates potential impacts to the public, the environment, and wildlife. The location of the state North Platte Fed F36 pad avoids potential impacts to RBUs, BUs, HPH, DI communities, schools and childcare facilities, floodplains, public water systems, wetlands, and riparian corridors. The proposed location is over 4,100 feet from HPH and over 1 mile from all other receptors. Where potential impacts cannot be completely avoided, the North Platte OGDP contains measures to minimize the extent and severity of potential impacts from operations. These include the utilization of an existing location and infrastructure, which will help to minimize additional surface impacts of the planned oil and gas development. Additionally, Bonanza Creek will employ Tier 4 equivalent or better frac engines for its completions, and all new wells will produce through existing pipelines for oil, gas, and water. Lastly, the North Platte OGDP contains mitigations to further alleviate the extent and severity of potential impacts, including the upgrading of the state North Platte Fed F36 pad to use instrument air and maintenance vessels to eliminate atmospheric maintenance emissions, and this location will remain tankless. As we stated earlier, no petitions were received against this OGDP, and no comments were provided from the public. Additionally, pursuant to Rule 306B, the director's recommendation finds that the North Platte 13-24-25 OGDP and the spacing application comply with all requirements of the Commission's rules, and in the director's judgment, protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. We thank you again for your time and ask that the North Platte 13-24-25 OGDP be approved following your deliberations. This concludes our presentation. Thank you again for your time. Jeff,
very good. If you want to pull down the screen share, that would be helpful. Great. Now I can see everybody. Commissioners, the panel is open for questions. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the presentation today. I was appreciative of some of the things that this application brings to the table, like using an existing location and piping all of your fluids. I'm going to probably ask a question I think Commissioner Ackerman was maybe thinking about previously, which is the Form 2B. And when I'm looking at the application, these additional fluids are all going to be piped to an existing processing facility. And then there will be additional emissions because of that at your existing processing facility. Am I reading your Form 2B correctly?
Yes, that's a great question, Commissioner McGowan. Yes, there will be additional processing done at the central processing facility that the oil, water, and gas are piped to.
And this is just only for my own education. You all have a permit with CDPHE for that existing processing facility. Do you have to update that permit because the emissions will change, or does that permit already had it already anticipated this additional activity?
I would have to reach out to our air team, but I do believe they are working with CDPHE. If there are updates needed, those updates will be submitted to CDPHE.
Thank you. And I'm appreciative that you're moving to Tier 2 dual fuel. Do you know if CDPHE's new NOx rules will allow the Tier 2 drilling during high ozone season? Because I think you're going to be drilling and doing completions, or maybe you're starting drilling before ozone season in April, and the completions is in August. So are you going to be aligned with the new NOx rules over at CDPHE?
Yes, we're aware of the new CDPHE rules, and drilling does commence outside of ozone season. I think actually completes outside of ozone season. So I'd have to re-review those rules. I believe outside of CICs and DICs, tier 2 dual fuel is still allowed, but don't quote me on that. I'd have to review that.
Okay, that's really helpful. That's all I have. Thanks.
Other questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. Couple of questions. I actually want to follow up on Commissioner McGowan's question. How many days do you anticipate drilling to take?
I will probably defer this question to Caleb Roush. Great question, Commissioner Messner. I believe there's a mixture of wells in there, but I'll go ahead and defer to Caleb for that.
Thanks for the question, Commissioner Messner. I think it's around estimated to be around a month, so like 30 to 35 days.
Okay. Thanks for that. I'm just going to ask some general questions here. I think as Commissioner McGowan indicated, I think the location choice here certainly avoids a lot of potential impacts to sensitive receptors, and so I appreciate that. But I also think it's important for me to fully understand your evaluation as how you're making a showing that you're avoiding, minimizing, and mitigating certain impacts to particularly air resources. And so I'm just trying to understand some of the evaluation that you went through. So I wonder if you could talk about the barriers to electrification on this particular site and why a decision was not made to pursue that.
Due to the remote nature of this location, electricity to power a rig wasn't available. That's what I've been told from our electrical department, that they looked at the area and didn't think it was feasible to have sufficient electricity to power the rig.
Was there any consideration given to, and I'm just trying to understand, I'm trying to help you make a finding as to why you chose to not do certain things. And so I'm curious about any potential barriers to electrification of the production facility.
I believe we're in the process of looking at electrification. There's not a whole lot of pieces of equipment on this location that would require electrification. There's a few pumps, but the bulk of the equipment is on the CPF. So we are looking into that, and if it is possible, we will be electrifying. But I think we're still in the process of looking into that load capacity and if it's possible there.
And the production facility itself, the existing one that the fluids would be piped to, not electrified?
I'm gonna ask some of my associates. I believe it is, but I'll ask and see if that is located. But can I defer for a bit, just to confirm? I want to make sure I give you a correct answer.
Yeah, that's fine. And just for my understanding, I understand that we're piping off of location, to a production facility, and then I assume that the products from the production facility are being piped from there. Is that correct? Or?
So there is an oil pipe that services the location. I think the water is currently trucked off of there. We looked into, I don't think there's any close nearby disposal wells that justify laying the produced water pipe for that. So we did look into that, and it wasn't feasible to lay produced water pipe to that location.
And just so I make sure that I understand what's being proposed here, and I certainly read your application and your presentation, but in addition to the pieces of equipment that you've identified in your presentation, there is an intent to use tier 2 diesel or tier 2 dual fuel engines for drilling. There's, I assume, an intent to use tier 2 diesel engines for generators for the production or for the facility itself, as it's not tied to electricity. Is that all true? And has that been captured in the cumulative plan?
Yes, that is correct, and it has captured, was captured in the associated emissions.
Okay.
And the
I think those are the questions I have. Thank you.
Further questions from commissioners to the panel? All right, thank you, panel, for the presentation. We appreciate you being here. We'll now move into deliberations. Commissioner McGowan.
Oh, fat finger, sorry. So I find this to be an approvable application. I appreciate that we're choosing a site that already exists and piping all of our fluids to an existing location. It appears that they're going to be drilling outside of the non-attainment high season, and we're not in a disproportionately impacted community. We're not in high priority habitat. I think this is a pretty thoughtful application, and I appreciate that instead of just tier 2 diesel, we're at least using dual fuel. And I think they've explained why they can't use the tier 4 engine, the one tier 4 rig that they have available. So I would move to approve this application.
We have a motion. Do we have other deliberative thoughts, or do we have a second?
Second.
Motion and a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. McGee, for the presentation. Thank you for proposing a approvable location, and we appreciate that work and appreciate the work of staff getting it to us at this point in time. It is 10:48. Let's return at 10:53 for our last docket, 2303-00083. It'll take about 5 minutes to get it set up and running. All right. We're now taking up 2303-00083. This is an oil and gas development plan, Summit Oil and Gas, the Castor 7-59-9 OGDP. Do we have someone from Weld County to initiate presentation?
Yes, Chair Robbins, this is Jason Maxey with the Oil
Oh,
and
hey,
Gas
Jason.
Department.
Sorry, you were right there in the middle, so I missed you. Go ahead.
No problem. I tend to blend in. Good morning, commissioners. Thank you for the time. As always, we appreciate the opportunity to get before you and just give a few brief comments about the Weld County process for our 1041 WOGLAs that we consider. And I hope everyone has been enjoying the nice Colorado weather these last few days. So we just wanted to talk about the Castor 7-59-9 pad, which is in front of you right now for consideration, and let you all know that we held a pre-app meeting for this location on November 9th of 2022. At that pre-app meeting, several alternative sites were discussed per the Weld County process that we have for pre-applications. Attendees not only included just Weld County staff and the applicant, Summit Oil and Gas, they also did include ECMC staff, CPW staff as well. We did include and we invited CDPHE and the BLM, but neither of those organizations were able to attend. Regardless of the fact, all attendees or people who we invited did receive copies of our official meeting notes from that pre-application meeting. Since then, we have assigned 1041 WOGLA 22-0043 as the assigned WOGLA number for Weld County. We received our initial application from Summit on January 2nd of 2023, and had some further discussion to clarify and enhance certain items within the application. And we received our final application version that we got on January 31st, 2023. So a few weeks after the initial submittal. The application for Weld County did include an analysis of 5 alternative sites, which were reviewed and discussed in detail with our staff as well as our hearing officer. Within the application, it's good to note that there are no Weld County defined building units within the 1041 WOCLA zone, which is 2,000 feet from the edge of the ultimate disturbance, which is a little bit further than the working pad surface. And we sent notice to multiple individual property owners within the area about our hearing that was upcoming, because we wanted to make sure that the public had that notice. And from that notice, we did not receive any public comments. We also did not receive any requests to participate in the hearing either. We sent out referral requests to multiple agencies on February 15th of 2023. We did receive responses from multiple Weld County internal referral parties, along with the CPW, the ECMC, and the CDPHE. We held our hearing on April 6th of last year, 2023. And at that hearing, our hearing officer considered testimony. And at the conclusion of the hearing, he found the application complete and compliant with Weld County code requirements and subsequently approved the permit. I did want to go ahead and call out one of our interactions with a referral entity that has been a part of this process ever since the pre-application, and that's just CPW's referral. I'm going to let the applicant, of course, get more into their citing and everything like that. I don't want to speak for the applicant. I just simply wanted to call out the fact that in case any of the commissioners reviewed our application and saw the referral from CPW, CPW did say in their referral that they had a preference to a couple of the alternatives that Summit was providing in their application. And to that end, that their goal was to maximize the amount of unfragmented wildlife habitats. Again, the applicant will talk about their alternative siting, but they provided a lot of testimony in their application, written testimony as well as verbal testimony related to the 2 alternates that CPW called out. Those are labeled A and E. During our hearing, the hearing officer found that based on the application and testimony from the applicant, that alternatives A and E might have some technical feasibility issues due to testimony, but also we did not consider, or we did not find, the hearing officer did not find that they provided any additional benefits from the proposed location that was in front of us and that is in front of you at this time. The hearing officer ordered the permittee, the applicant, to agree to be bound by all the BMPs within the submitted wildlife mitigation plan, along with complying with the 16 high priority habitat requirements that are listed in Weld County Code. And the applicant agreed to both of those. I just wanted to highlight that because we do take our referral process seriously and our conversations that we have with our referral partners seriously. And that was a big point of discussion. And I believe the applicant will probably get into that a little bit more, but I did want to call that out. Our final order was recorded on April 19th, 2023, and published in the Greeley Tribune on April 21st, just a couple days later. We believe from a land use perspective, from a surface perspective, that this is a good location. The word close, I think, is relative. It is close to other oil and gas development to the southeast. But when I say close, it's easily a mile away from some other oil and gas development that has been permitted in the recent past. We submitted 2A comments to you all on December 4th of 2023. They are included in your director's recommendation. We have read through the director's recommendation that we received, and we do agree and support approval of this permit on the ECMC side. I'll remain active on this call and be happy to answer any questions if you have right now or further on. So thank you very much for your time.
Thank you, Mr. Maxey. Appreciate Weld County as the relevant local government bringing their perspective to the table. Questions for Mr. Maxey? All right, well, if you want to stick around, that would be great. At this point, would recognize Mr. Willis. I see that you have some witnesses available. Should we go ahead and get them sworn in to get things started? Ms. Mercer?
Thank you, Mr.
Could I ask that Mr. Dullock be elevated to a panelist, Brent Dullock?
Okay, we're working on that.
While he's being elevated, I can begin with the other panelists if you'd like, Mr. Chair.
Yep.
Great. Well, good morning to the panel. What I'll do is just go one at a time and ask you each to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Bradley.
My name is Sam Bradley, and I swear to tell the truth.
Thank you. Mr. Pitsley?
My name is Ben Pitsley. I swear to tell the truth.
Thank you. Mr. Doka?
Hi, I'm Edward Doka. I swear to tell the truth.
Thank you. Mr. Dornbos?
I'm Ryan Dornbos, and I swear to tell the truth.
Thank you. Mr. Dulac?
My name is Brent Dulac, and I swear to tell the truth.
Thank you. Mr. Dominic? Oh, we can't hear you, sir, if you could unmute.
Sorry, my name is Mick Dominic. I swear to tell the truth.
Thank you. Mr. Willis, is that everybody?
It is, thank you.
Thank you.
Good morning, Commissioners. My name is Rob Willis with Post Nodell Peterson Law Firm, and I represent Summit Oil and Gas LLC today in its Castor 759-9 OGDP application in ECMC docket number 2303-00083, which has been noticed according to your rules, and I just state that there are no known protests, petitions, or objections which have been filed. On behalf of Summit, I'd like to thank Jason Maxey and Weld County for its contemplative processing of the WOGLA and their support of the OGDP, along with ECMC sister agencies' reviews at CDPHE and CPW. Further, I need to thank ECM staff for their efforts on behalf of this OGDP, which is manifested in the director's recommendation recommending approval. With that said, I'll turn the presentation over to Ben Pitsley, a member of Summit Oil and Gas.
Thank you. Sam Bradley will run the presentation.
You guys see my screen?
Yes.
Morning, Commissioners. My name is Ben Pitsley. I'm a partner at Summit Oil and Gas and have been in the energy sector for nearly 2 decades. Joining me today is Sam Bradley, my partner, a seasoned petroleum engineer with 15 years industry experience. Brent Dulac, our operations and production manager, brings 20 years of invaluable experience to the table. Both Sam and Brent are alumni of the Colorado School of Mines. On the line, we have Ed Doka, our VP of Land, with 15 years experience, most of which has been spent in the DJ Basin. We also have Mick Dominic and Ryan Dornbos, our contract geologist and petroleum engineer, who provided us with third-party testimony for the drilling and spacing unit application. Many of you are already familiar with Sam and I. Sam entered the basin in 2013, and I had the privilege of joining this dynamic field in 2015. Together, we've supported numerous energy firms in their pursuit of responsible asset development. For the years, we've had the opportunity to engage with many of you on a range of topics, sharing our insights and learning from your perspectives. However, today marks a significant milestone as we present to you from the platform of our operating arm, Summit Oil and Gas. We established this firm in 2021. Since then, we have been diligently operating 2 pad locations within 3 miles of this proposed location. Our agenda today encompasses not only the specifics of this proposed location, but our commitment to best management practices. We want to emphasize the meticulous and responsible approach we have taken in our site selection process. You can see from the maps and aerial imagery provided, the pad is located in northeast Weld County, just west of New Raymer, lies in a relatively remote area of the DJ Basin, location chosen with careful consideration of environmental, social, and operational factors.
Please.
Okay, thank you, commissioners. I'm gonna talk a little bit here for a couple slides. And again, we appreciate the commission's time, the commissioners and staff's time on considering this proposed OGDP. I would like to take 2 slides here. My name is Sam Bradley. I'm partner in Summit Oil and Gas. Talk about some unique geologic and engineering challenges that this proposed OGDP presents that did factor into our alternative location analysis process. So I'm just going to take a couple slides, try not to make your eyes roll back in your head, and sort of tee up the ALA discussion that comes. And Ben will present that work. We're on slide number 2 here, and we're just going to kind of get you guys oriented. So, get caught up here. So the geology and production stream for this proposed location is expected to hold significantly different oil and gas ratios from typical Niobrara and Codell wells in the basin. This difference adds engineering and operational challenges, which Summit has learned from the neighboring Castor 12 and Castor 11 pads we currently operate. Shown on the left of this slide is a published thermal maturity map across the DJ Basin from Dr. Sonnenberg at Colorado School of Mines. You can see the Castor 9 proposed location resides outside of the greater Wattenberg area, or GWA, which is shown in the red box on the map on the left. Significance of Dr. Sonnenberg's thermal maturity map is that as thermal maturity decreases and you move away from the geologic hotspot or cooking pot of GWA, less hydrocarbons have been converted from oil to gas. The reservoir has less energy to expel when new wells are added. The map on the right of this slide shows an outline of Weld County, and purple lines and dots are wells. I've put some call-outs in this map from the ECMC website that talks about producing gas-oil ratios. In the core of Wattenberg, we see producing gas-oil ratios up to and around 15,000 standard cubic feet per barrel. As you step out into what I call the northeast extension, these GORs decline significantly to around 2,000 standard cubic feet per barrel. The proposed Castor 9 location is on the fringe of this northeast extension, and we expect that location, I lost my mouse, to have a producing GOR of around 500 standard cubic feet per barrel. This is similar to the producing GORs of Summit's neighboring pads, which would be called the Castor 12 pad and the Castor 11 pad. Again, the reason I'm telling you all this is because these low GORs do create some unique operational and engineering challenges. So now we're moving to slide 3. We're going to zoom in on the northeast extension and talk a little more. Let's go into more detail on the northeast extension. And again, I'm going to get through this fairly quickly. I'm trying not to have your eyes roll back in your head. But it's important for us to stress uniqueness of the Castor 9 proposed location. Shown here is a zoom map of the surrounding area from the ECMC website. I grabbed this map a couple weeks ago, so it's fairly fresh. Purple and green sticks are existing wells and approved permits, and blue sticks are pending permits. In the far south side of the map, you can see the proposed Castor 9 DSU. The center of this northeast extension area has wells with up to 5,000 SCF per barrel gas oil ratios. You can see a call out at 4555, a call out at 1617, a call out at 1100. So the values immediately to the west of the Castor 9 DSU has producing gas oil ratios of around 1,000 standard cubic feet per barrel. And the wells immediately to the east of the proposed Castor 9 DSU, which would be the Castor 11 and Castor 12 producing DSUs, have producing GORs of around 500 standard cubic feet per barrel. As a result of these surrounding producing gas oil ratios, Castor 9 proposed DSU is expected to have very little gas energy in the producing stream. This is important to understand as it poses operational and engineering risks and challenges associated with both long-term production operations and operations during drilling and completion phase. I'd like to talk a little more detail about these challenges, and let's start with the long-term production challenges. From a long-term standpoint, it is likely that the proposed Castor 9 wells will need to be produced using a rod pump, as the low bottom hole pressure and low GOR will not be conducive to production methods used for gas and condensate wells, such as plunger lift. The rod pump requires setting a pumping unit at each wellhead in order to stroke the downhole pump via a string of rods. You stroke a string of rods and pump up and down through tubing in a slanted or directional well. Rods wear on the side of the tubing, and this occurs primarily where there are changes in direction or a lot of inclination in the wellbore. Moving rods rub holes in the tubing, causing rig mobilizations for maintenance events, production downtime, and I already mentioned frequent maintenance activities. This is not only financially inefficient for both the operator and the mineral owners, but it also causes increased emissions through things like well blowdown events, vehicle emissions, disturbance to wildlife due to frequent rig mobilizations, and additional opportunities for harm to occur to crews or the general public simply due to the nature of unnecessary maintenance activities. As the step-out length or inclination of the vertical portion of the wellbore is increased, the number of rods needed to get the pump placed at depth increases as well. More rods means more weight, and more weight requires a larger pumping unit. If wells are drilled from the proposed location, which we'll see in the next couple slides is in the middle of the proposed DSU, the wellbore with the longest step out would require a pumping unit that would be about 15 feet tall at its highest point. Wells are drilled from the eastern or western edge of the DSU. The wellbore with the longest step out would require a 40-foot tall pumping unit in order to pump the wells. Pumping units that would be used for this purpose would not only need to be larger to handle more rod weight, but taller so they would be able to stroke a longer pump at a lower rate in order to reduce the amount of damage to the rods and tubing. Summit, and specifically myself, did have a very specific discussion about this with ECMC staff, specifically Diana Byrne, as this pad was contemplated and planned, especially after we observed another operator's attempt to communicate this concept to the commission when they were permitting a location near the Wyoming border, which is also a low producing gas oil ratio area. We hope we've clearly expressed our concerns on this subject and are happy to discuss more. Give me a couple more minutes on this slide, because I would like to talk about the operational and engineering challenges associated with the drilling and completion activities in low gas oil ratio areas. Summit is not as concerned with the drilling phase, although wells longer than 2 miles do pose increased risk in low GOR regimes when compared to higher GOR regimes. However, the risk associated with drilling a 3rd mile are very high in the completion phase. More specifically, when drilling out frac plugs. Drilling out frac plugs after the frac is required for the full wellbore to efficiently contribute to draining the spacing unit. Higher gas oil ratio areas inherently provide a benefit to operators, as they may utilize reservoir gas during this operation to clean the hole or get a drill string unstuck if necessary. Low GOR areas do not have this benefit, and the only way to minimize the risk of issues in the 2nd or 3rd mile during drill out is to have as smooth of a wellbore as possible from top to bottom, which essentially would be a well that goes straight down, turns horizontal, goes straight out for 2 or 3 miles. It is important to note that these concepts, and I'm going to make my mouse wake back up here, these concepts and risks are not new to the Northeast Extension area. The first wells drilled longer than 2.5 miles in this area did not turn on until 2022, shown on this map. Since then, several operators have submitted some highly aggressive permits, and these would be the blue permits that I have called out from Bison, 4, MDS, and Civitas. However, it's important to point out that the operational success of these aggressive 3-mile wells and U-turn wells is not proven in this area. And as you can see on this map, it is likely that these proposed blue permits are in higher gas oil ratio regimes than the proposed Castor 9 on the south of the map. There's one last point I'd like to make on this map, and it was asked by ECMC staff during our last discussion, and Summit believes so strongly in these facts that we recently vacated some permits on Castor 11, which my mouse is over, that are on the far east side of the drilling and spacing unit due to the significant step out that would be required to drill those permits from a surface location on the far west side of the spacing unit. I'm going to turn it back over to Ben Pitsley to continue the presentation. We're happy to answer more questions or discuss this more at the conclusion.
All right. This proposed location is strategically centered in Section 9, Township 7 North, Range 59 West. The proposed location has a mutually beneficial surface use agreement with Castor Lands LLC, who currently uses the location as cropland. Meticulous planning aims to minimize our operational footprint Commitment evidenced by the selection of one optimal surface location. Site enables us to access minerals across 3 sections. 2 are fee-based, 1 is state-owned, thereby maximizing resource utilization while minimizing land disturbance. We plan to develop up to 16 horizontal wells with 1.5-mile lateral lengths. These wells, drilled both north and south, will adhere to step-out distances not exceeding 2,100 feet. 3 sections in size, proposed drill spacing unit is 50% larger than the industry norm. It is already disturbed by county roads that entirely surround it. Footprint, including the access road, initially spans approximately 24 acres until interim reclamation occurs, at which point 29% of the disturbance will be reclaimed, creating a long-term surface disturbance of approximately 18 acres. Access to the proposed location will include a 2,038-foot-long stretch from the east, connecting with Weld County Road 115. Use of CR 115 is the same route utilized by existing pad locations to the east of this proposal, operated by both ourselves, Summit Oil and Gas, and MDS Energy Development. Proposed location, which holds an approved 1041 WOGLA, is strategically placed to avoid sensitive areas. Proposed location has no building units, residential building units, public roads, utility lines, property lines, schools, childcare centers, parks, or disadvantaged communities within 2,000 feet. Drawing parallels with the 2 pads operated by Summit Oil and Gas to the east, our proposed location is situated in a high priority habitat. It includes the mule deer severe winter range and the pronghorn winter concentration area. In planning this project, we diligently sought to balance the needs and rights of stakeholders, carefully aligned our operations with Weld County's purpose, intent, and authority, and adhered to ECMC's effective scope of rules and regulations. Our objective for this project has always been to site a location that not only mitigates material adverse impacts, but also minimizes potential waste, efficiently utilizes public resources, and harmonizes the rights associated with mineral property ownership with robust environmental protections. We are steadfast in our commitment to safeguarding public health, safety, welfare, the environment, and wildlife resources. Let's get into the siting methodology, bring you through the thought process. In choosing the proposed location, designed for the development of 16 Niobrara wells, we consciously decided against including Codell targets. The decision was not taken lightly. In this area of the DJ Basin, a combination of Niobrara and Codell targets is typical. However, after careful evaluation, we determined Codell productivity to be questionable for this location. Led us to permit a lower than typical well count. The direct result is a significant reduction in total truck traffic over this location's lifespan, thereby lessening our environmental footprint and accelerating the time for interim reclamation. From the outset, we were committed to minimizing our impact. One of our early decisions was to ensure electricity is available from day one. Choice significantly reduces emissions and noise, aligning with our philosophy of minimizing additional adverse impacts on wildlife resources. We would apply the term additional in this case, as there is clearly surface development in the region. Perhaps most obvious is the fact that the proposed 3-section DSU is entirely surrounded by County Road 86, 113, 80, and 115. Our journey to the proposed location was guided by a desire to balance the interests of all stakeholders. Given that all 3 leased sections fall within the high priority habitat region, the primary aim was to minimize surface disturbance. It was achieved by establishing one surface location to access minerals from all three sections, thereby reducing additional adverse impacts on wildlife resources. Wildlife consultation with CPW revealed the presence of pronghorn herds crossing CR 115 a mile northeast of this location, reinforcing our commitment to minimize disturbances in this critical area. Next thought was to minimize subsurface wellbore step-out distances while maximizing our surface distances from 5 key features, those being number 1, residential building units as indicated by blue circles on the map. Number 2, the distance from the grouse production region east of the Castor 7-5911 site. Number 3, the distance from the aquatic native species overlay near alternative location E. Number 4, distance to existing oil and gas operations in an attempt to prevent the creation of an invisible wall where wildlife is deterred from moving freely. Number 5, actually to minimize the distance to the westernmost boundary of the mule deer severe winter range in an attempt to remain close to the outer edge of that HPH overlay. All of the alternative locations, that of our proposed location, pose similar benefits when it comes to distances to homes, buildings, schools, childcare centers, parks, guides, communities. We have to dig a little deeper to understand the nuances. We look at alternative location A. Now this would have located us outside the mule deer HPH. It remains within the pronghorn winter concentration region. While this alternative location would have moved us further from existing oil and gas development, the mule deer winter concentration region, and the aquatic native species, it would have moved us closer to public roadways, property lines, power lines, as well as placing us within 2,500 feet of residential buildings, while requiring us to develop 3-mile wells to drain the spacing unit, which was determined not to be an operationally viable choice, as previously discussed by Sam. We look at alternative location B. Location would have resulted in identical issues to that of alternative location A when it comes to the 3-mile wells discussed by Sam, as well as the increased proximity to residential building units. Additionally, this alternative location posed an added difficulty in connecting the pad to gas takeaway. Run through section 4, approximately 2.5 miles north of this alternative location B. That's 2 miles further away than our proposed location provides for. Lastly, an existing dirt pit is currently located in this section, entirely fenced off from the public and wildlife. Alternative location C and D are very similar to our proposed locations, or proposed location. Alternative location C would have moved us closer to the northern edge of the mule deer high priority habitat, a benefit for sure. That said, both C and D would require a mix of 1- and 2-mile wells. In our industry, we prefer continuity in operation. We wash, rinse, repeat. Our experience, this helps mitigate confusion and that can occur during development programs. Additionally, and importantly, discussions with the surface owner led us towards the center of the section rather than the north or the south. Lastly, but not least, alternative location E. While similar in a lot of ways to our proposed location in the center of section 9, this alternative location would have moved us to within 525 feet of the aquatic native species. Additionally, alternative location E would have moved us 1,800 feet or 37% closer to existing oil and gas development, that being DSU 10, increasing the potential for the invisible wall, wildlife. Furthermore, this alternative location would have moved us closer to the grouse production region as well, public roadways, property lines, power lines, while sending us further from the western edge of the mule deer severe winter range. Alternative location E not only double the wellbore step-out distance from 2,100 feet to 4,100 feet, would extend the maximum total measured distance drilled by 20% to 12,020 feet as we reach the western flank wells. Moreover, there are concerns around the feasibility of such development, as increased failure rates may occur not only during development, but over the life of production, as Sam discussed. Potentially leads us toward greater ongoing operational costs, workover, truck traffic, and even waste if the operator determines to plug and abandon the well prematurely when compared to developing the minerals from the proposed location. In conclusion, the proposed location strikes the most effective balance between operational efficiency, environmental stewardship, stakeholder considerations. It minimizes impact on wildlife, adheres to regional guidelines, and aligns with our commitment to responsible resource development. Discuss the midstream situation in this part of the basin, recognizing that Summit Oil and Gas is an upstream exploration and production firm. Let's turn our attention to what the midstream firms in our industry have made available in this fringe portion of the Northeast extension. Summit Oil and Gas currently holds an executed gas gathering and processing contract with Summit Midstream, with whom we share a name but no corporate affiliation. Summit Midstream's gathering line, conveniently located just a half-mile north of our proposed location in Section 4, presents an ideal tie-in opportunity for us. This strategic proximity allows for an efficient and environmentally responsible approach to gas gathering. We have begun planning the tie-in with Summit Midstream with an aim to lay the pipe in the coming months. To address the challenge around produced water management, as we're currently without midstream pipeline solutions in this region. Consistent with our operations on 2 other pads to the east, DSU 11 and 12, our initial plan involves transporting produced water to Expedition's SWD facility. Alternative facilities like Tallgrass's Wild Horse and Razor are also in our contingency plans, ensuring operational flexibility. However, we are acutely aware that hauling water is not the most sustainable option. With a vision for a greener and more efficient future, we initiated discussions 19 months ago in June of 2022 with Energy Select about transporting our produced water by pipeline to their Weitzel No. 1 well, located approximately 4 miles from our proposed location. This well, already drilled and tested, pending a disposal permit. We are keenly anticipating this approval, as it would significantly enhance our ability to manage produced water more sustainably, benefiting both our proposed location and existing locations. Regarding crude oil, our immediate plan involves transporting barrels from the proposed location to the Buckingham Crude Terminal. We recognize the long-term environmental and operational benefits of pipeline transport. We are hopeful that midstream development in this region will occur. Hope is not a strategy. We have actively pursued tangible solutions. In late 2022, I personally invested considerable time assisting a midstream firm in their effort to finance a crude gathering system here. Unfortunately, despite our best efforts, the project did not materialize due to low levels of volume in the region. Summit, our goal, be it for produced water or crude volume, transition to pipeline transport. I believe this not only aligns with our operational efficiency goals, but also significantly reduces our environmental impact, echoing our commitment to responsible resource management and sustainable industry practices. Slide, please. Let's talk about the best management practices, BMPs, and some COAs. I'm going to address the Colorado Parks and Wildlife COAs right up front, and then I'll turn this over to our operations and production manager, Brent, to discuss the remaining topics. We have committed to form performing a plain sharp-tailed grouse survey prior to any construction. They tentatively teed this up already for September with tender. We have committed to void construction activity annually, January through April. During that time, we've committed to a single site visit from 10 a.m. to 3 p.m. We committed to no fencing, and graciously, CPW modified that to allow us fencing if needed. Of course, it needed to be CPW recommended designs, which we were provided information on. We have committed to employ noise minimization efforts in L1 levels, December through April, and L4 outside periods, as well as light, dust, odor, and mitigation. And we have agreed to compensate CPW to offset direct and indirect HH impact. With that, I'll turn it over to you, Brent.
Thank you, Ben, and thank you, commissioners. I'd like to go over our responses to questions. I'm sorry. I'd like to talk about our development phase in EMPs that we have agreed that we will use oil-based mud for drilling. We'll use a minimum of tier two with dual fuel rigs, battery backup. We have sourced these from pro vendors, and we're confident that one. For hydraulic fracturing vendor.
Sorry, is anyone else having trouble hearing the speaker, or is it just me? Like, he's coming in and out for me.
Okay, sorry, Commissioner. For the hydraulic fracturing operations, we will use tier 4 engines at a minimum. Our flowback will be routed through our permanent production facilities with no venting through the atmosphere. Our air monitoring plan approved by CDPHE, we will use Project Canary sensors during all of the operational period. And we will utilize sound walls around the entire pad to minimize noise and light impact. The production phase, we will have electrification to the pad prior to production. We have not permitted and will not use any gas-fired engines. We'll have no permanent lighting on the pad. We'll use closed-loop system. All tank vapors will be captured and routed to the gas sales line. Daily site monitoring with automated remote control and shutdown capabilities. We'll perform AVO and LDAR inspections monthly. Vapors from loadout will be contained and controlled. Natural gas production will be via pipeline. We will, as Ben said, we're looking forward to having oil and water takeaway via pipeline, and we'll continue to pursue this. We'll restrict our speed limit on the proposed access road to 5 miles per hour to reduce dust. Whatever other mitigation is required.
So we received a number of questions from commissioners yesterday. Brent will take us through 5 of them, and I will finish with 2. I hope no one minds we move just a couple of questions around. It's easier to understand. So with that, Brent?
Okay, thanks, Ben. Okay, the first question had to do with minimizing are produced oil and water tanks that we've proposed on the permit. We initially proposed 24 oil, 24 water tanks, total of 48 tanks. On review and along with lessons learned from our other two producing locations, we believe that we can commit to reducing our tank battery size to a maximum of 24 total tanks. That'd be 12 oil, 12 water. As discussed, we're looking forward to having the ability to connect to oil and water pipelines, at which point we will have the ability to remove all unneeded storage tanks. The second question, Summit committing to a natural gas connection before production or proposing. We are committed to not starting flowback or producing any hydrocarbons into our facility until natural gas takeaway connection is made. Just yesterday, we were in communication with Summit Midstream, planning our connection for a tie-in for Q2 of 2024, prior to feeding the wells and going into production. Third question, under from the CI plan, page 5, under minimization and mitigation measures, there is a bullet that simply says electricity. What does that mean, and what is the commitment? Provide some insight on that. Summit will have electric power connected prior to first production. There are no gas engines that are permitted in our site equipment list. Following equipment that will be used in the process facility is necessary for production and powered by electricity. It means that we would not be able to produce without this and must have electricity. We'll have an electric motor BRU, an electric motor air compressor for valve actuation. We will not use gas pneumatic valves. We'll use an electrical submersible pump for well production, as well as our automation system, which is required to produce the facility and is powered by electricity. Fourth question from CI plan, also under minimization and mitigation, auto gauging to eliminate thief hatch openings during loadouts. Could you please explain how this system works and minimizes potential emissions? Summit Oil and Gas uses electronic tank level devices on all tanks with a readout screen that is accessible to all contractors. Tank level reading is used by the truck drivers and the operators for tank preparation and for truck loadout. At no time are thief hatches opened for loadouts or at any other time for any other daily activity. Question 5. From the CI plan, SOG will try to deploy a quiet frac fleet to further minimize cumulative noise impacts during fracturing operations. SOG will try to locate water transfer pumps within the deployed noise mitigation areas where possible. A water transfer pump has to be located off location. Summit Oil and Gas will make sure that it is mitigated to adhere to NL4 permissible noise levels. Please tell the Commission if Summit can commit to the ECMPs. The answer is Summit can commit and does commit to deploying a quiet frac fleet. The water transfer pumps will be accepted for use for Summit frac jobs unless they meet or are mitigated to meet the NL4 permissible noise level standard. It's our understanding under Section 21-5-435A of the Weld County Code that within the ag rural planning areas, operators must comply with the maximum permissible noise level for the NL4 standard. Committed to doing that.
Thank you, Brent. I'm going to move. Sorry, just needed to move the speaker. The final two questions. In the Form 2B, can Summit explain how there are no producing wells within a 1 mile radius, but there are 24 oil tanks and 12 produced water tanks in a 1 mile radius? That's a good question. and there's something in there about the P&A well. So let me bring you through it. So on row 164 of the Form 2B, we indicated 4 wells within 1 mile of the working pad surface. They're either P&A'd or dry and abandoned, DEA. These 4 wells will become part of our offset well mitigation measures. On row 162 of the Form 2B, we indicated 2 wells are within 1 mile, 5,280 feet of the working pad surface. Were permitted but not drilled. On row 166 and 168, we then indicated 24 permitted oil tanks and 12 permitted water tanks were within 1 mile of our WPS. See how that might be confusing. Other than the P&A well count, these figures relate to the Castor 7-5910 pad operated by MDS to the east of our proposed location. Bring that up on the map.
I can go back to
when this document was created, MDS had not developed their wells yet. 2 of their permitted but undrilled wells were within 5,280 feet of our WPS. Fast forward to today, and MDS has 4 wells on DSU 10, and per ECMC records, their Form 2A is allowed for 24 oil tanks and 12 water tanks. But speaking to Brent today, since we operate the adjacent pad, we believe they have set 10 tanks. So fast forward to today, the conclusion is we have 4 operated wells on the pad, and we believe they have 10 tanks, but I'm sure that could be confirmed by reviewing their as-built survey. Hope that clears up confusion there. Last question, and this was the first question, and probably one of the most important. Can Summit please speak about how they applied SB 181's directive to first avoid, then minimize, and mitigate impacts from oil and gas development? SB 181 presented a significant shift in the regulatory landscape in Colorado as it emphasized the importance of prioritizing public health, safety, and environmental responsibility in the oil and gas industry. Break down our application of SB 181's directives one by one. Looking at avoidance. Avoidance can best be analyzed by assessing our approach to site selection and our pre-planning measures and technology utilization. When it comes to site selection and pre-planning, would lean on the ALA testimony today. It illustrates a clear attempt to carefully select a site that avoids sensitive areas and is positioned good distance from existing oil and gas activity while making environmental commitments like performing a plain sharp-tailed grouse survey. Other more obvious environmental commitments include the avoidance of any construction from January through April annually, a commitment to set no fencing around this location unless determined absolutely necessary. As for technology utilization, the proper application of directional drilling to our region of the Northeast Extension helps us avoid the need for 2 surface disturbances. Look at minimization. Minimization can best be analyzed by assessing our footprint, emissions controls, water management, and noise reduction. Again, I would lean on our ALA testimony, highlighting the fact that from the outset, we intended to establish 1 location to access 3 sections, a DSU 50% larger than typical units, with a lower than typical well count as we target the Niobrara. Additionally, from day 1 of this project, we envisioned the use of electricity over gas-fired engines. We have been proactive in attempting to induce midstream pipelines in this region. Incidentally, it is our understanding that Energy Select Whitesell number 1 well is part of a greater project that includes water recycling, which would be of interest to us. I believe our commitment to noise reduction was addressed in our BMPs with NL1, NL4 commentary, and by the response that Brent has just, but we are happy to dive deeper into that discussion during Q&A as well. Then lastly, mitigation. Mitigation can best be analyzed by assessing our ongoing monitoring plans and compensation measures. We continuously monitor our sites, whether it be remotely through the use of emission sensors from Project Canary, monthly AVO and LDAR inspections, or daily visitations by Brent and/or our pumpers. The installation of automated remote controls and shutdown capabilities put into service as well. When it comes to compensation measures, in this situation where CPW has determined our impact is unavoidable, we have committed to direct and indirect compensatory compensation. With that, I'll turn it over.
Gentlemen, thank you for the presentation. Chairman Robbins, thank you for your patience and the indulgence of the commissioners in listening to this very important and technical presentation by Summit Oil and Gas. The panel is here for any additional questions you might have. Otherwise, that concludes our presentation. Thank you.
Okay, thank you very much. First, before we jump into this, there's a lot here. Do folks want to, and by folks, I mean my fellow commissioners, do you want to take a short break, get some lunch, and then come back and dive into this? I think we're going to have some questions. There's a lot here. I'm seeing at least one head nodding in the up and down fashion. Are the rest of the commissioners okay if we say take 30, 45 minutes, and then we'll come back and jump into questions? Commissioner Cross?
I just have to pick up my son at just before 1 o'clock, and I can be back by 1:15.
Oh, okay. I mean, I'm good with that. This is our last thing on the agenda, so maybe we'll take a little bit longer and I'll go for a walk as well as get lunch. All right, let's return at 1:15. It is 11:54. Thanks, everybody.
Thank you.
All right, it looks like we are back. This is docket 2303-00083, an oil and gas development plan by Summit Oil and Gas. At this time, we've heard from the applicant, and we now will move into commissioners' questions. I have one discrete question to maybe kick it off, and it's to you, Mr. Bradley. By the way, it's good to see you again. It's been a while. You spent some time talking about the concept that some of the locations would need pump jacks. And then I think what you were trying to indicate is because the preferred location is where it is, that maybe it didn't. I totally wasn't following that line of testimony, and I wanted to give you a chance to elucidate that for me.
Yes, and thank you for the question. Can you hear me okay, Director?
Yeah,
or Chairman?
we can. Yes.
So your follow-up to your question is correct. And my answer is twofold. If we end up having to rod pump these wells, the proposed location is ideal to minimize maintenance events and emissions associated with maintenance events. What I didn't talk about, however, it got mentioned in the electrification portion, is we are testing some newer lift technology to the NIO Code L for these very low gas oil ratio areas, which is electric submersible downhole pumps. And we did install one on our well we did last year in Castor 11. It was just installed in December. And so far, because of the low gas oil ratio, it is working well, but we're not sure if that will be the correct solution 10 years from now. Does that make sense?
Yeah, so then follow up, so what's the point? What's the point you're trying to drive the decision makers to?
So the point is if we believe right now that ultimately these wells will need rod pumps, we want to make sure that the surface location and the downhole geometry of the wells are best suited to minimize maintenance events associated with stroking a rod string up and down through tubing.
And your opinion then is that the preferred location, the asked for location, is indeed that preferred location if there's the need for rod pumps compared to the other ones. And that has to do with the dynamics of drilling or the offsets or whatever. Is that right?
Yes, sir. We call it a step out, but it would be minimizing the vertical section of the hole, the degrees of inclination that the vertical section of the hole is at. And so a centrally located surface location minimize how crooked the vertical section of the holes need to be.
And so the contrary point would be if you are requested to go to one of the other 4 ALAs, the susceptibleness to rod pumps needing maintenance and having problems is greater, which has more implications as potentially as to wildlife concerns. Is that right?
Correct. That's correct. If we were forced to put the location on the far east or the far west side of the DSU, that's correct.
Okay. Okay, I think that clarifies at least that angle on the testimony that I just totally wasn't quite understanding. So thank you for allowing me to ask that question. I'm sure I'll have more, but at this point, looking around to my fellow commissioners, and Commissioner Messner and Ackerman both raised their hand. I don't care who wants to go first.
Mr. Chair, Mr. Commissioner Messner, if you permit me,
Are you okay with that, John?
And not necessarily usurping that, just asking a question. Predictably, most of my concerns are associated with wildlife on this one, and at some point I'd like to hear from CPW and their take on it. Would that be appropriate now prior to the rest of our questions, or do you want to wait to do that?
Commissioner Ackerman, are you indicating perhaps bringing in Mr. Moret?
Yes.
Yeah, I think it makes more sense to bring him in to ask questions before we go further with the commissioners. Commissioner Messner, did you have a thought?
Yeah, I want to clarify something before we bring Mr. Moret in. I do think that's a good idea, and I appreciate that suggestion. But I'm trying to better understand a couple of things that are being committed to here from a wildlife standpoint. So one, I want to clarify, at least in my notes from your transportation plan, it appears that that you'll be trucking oil and water, a minimum of about 15 truck trips a day, a maximum of about 90 truck trips a day, depending on where you are in the production bell curve. You've also committed to a timing stip during the high priority habitat pronghorn winter concentration timing of 1 trip a day to location between 10 a.m. and 3 p.m. I'm trying to understand how the truck trips associated with this are going to be able to comply with that timing stip.
Let me just take that. So this is Sam Bradley, I'll take it, and if Brent wants to add color to it, he can, and I'm going to try to pull up specific language, COAs. The way the COAs were written on our other 2 pads in HPH is during wildlife season, truck traffic would happen during daylight hours only, and the site visits is more pertaining to pumper activities and pumper visits.
So you are anticipating somewhere between 15 and 90 truck trips a day through high priority habitat timing stips.
Yes, yes.
Okay.
And the way the COAs were written on the other 2 pads or that that traffic only occurs during daylight hours?
So my second question is that, again, I think you've committed to a timing step between January and April for construction, drilling, and completions. I think in testimony, it seemed to be indicated that you intend to tie into your gas pipeline and employ that construction in Q2, which appears to be in that timing step. And so I'm trying to understand that.
No, sorry. Thank you for the question. To clarify, it's late Q2, and in construction, it's typically delayed. It likely occurs into Q3. Built 2 lines with this midstream firm in the past. Would not occur January 1st and April 30th. Be clear.
All right, I just wanted to clarify that before Mr. Moret came forward, because it's not clear to me whether Mr. Moret understood that there would be somewhere between 50 and 90 truck trips a day. So 15 and 90, sorry. So that's all the questions I have. Thank you, Mr. Chair.
Finding the unmute button. Okay, Commissioner Ackerman, do you want to call for Mr. Moret to come visit with us?
I would, thank you. Yeah, I certainly have some questions, but I do think mine would be better informed by Mr. Moret. I appreciate Commissioner Messner's clarification.
I believe we've got hearings manager Amara this afternoon running the panel. And there we've got Mr. Moret. Good afternoon.
Good afternoon. Thanks, Chair Robbins and Commissioner Ackerman and members of the public. Thanks for this opportunity to hear my wildlife perspective on this OGDP. I just have a few quick points that I wanted to share, and I'm happy to answer any questions. For the record, my name is Brandon Moret. I am a certified wildlife biologist with extensive Northeast Colorado wildlife experience. I am CPW's Northeast Region Energy Liaison. Thus, that makes me ECMC's wildlife expert for this OGDP. So just real quickly, I've appreciated the ongoing consultation opportunities between Summit, Weld County, and ECMC. And even though this proposed location is in the least ideal spots in the middle of the section, I appreciate Summit's 11th hour change to avoid construction during the winter season based on a CPW recommendation. Plus, their other BMPs make this OGDP cross the threshold that this location is protective of wildlife resources. And as I mentioned in my wildlife consultation summary, CPW has no further objections or outstanding issues regarding this OGDP application. Commissioner Messner, I appreciate that clarification. So with that, that's sort of the short and sweet version for the wildlife consultation summary I've had with Summit.
Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Mr. Moret, for being here. And so did you hear the, it sounds like you heard the clarification from Commissioner Messner, and is that, were you formerly aware of that? Does that modify your stance?
No, and I think, and, you know, correct me if I'm wrong, the timing stipulation is, like you mentioned, Commissioner Messner, for drilling, construction, and completions activities. And then from there on, it's important for the next however long this well is, these wells are producing on the landscape, that, you know, there, I understand there will need to be maintenance activities that occur during January 1st to April 30th. And so to the extent possible that we can limit that, it sounds like Castor has, that that is appreciated to minimize their impact on wintering pronghorn.
Thanks, Mr. Moret. Finally, can you talk a little bit, you've mentioned this before about development for pronghorn in the center of sections, particularly on the Eastern Plains. Can you talk about why, and this operator has stated it's already disturbed because it's surrounded by roads. Can you talk about why the maintenance of the center of a section might be important for pronghorn in winter concentration areas?
Yeah, thanks for that. And so during the middle of sections, those can be a place of refuge for pronghorns, and it depends on how wide, how many miles across before the county roads happen. And so pronghorn prefer to get as far away from county roads or other development. Obviously, they have hunting pressure during the fall and winter months. But there's other types of developments too that they just like to run and get away so that they can see where there's a potential threat. And so, you know, these high priority habitats, they're important to maintain because, you know, these are obviously the most sensitive habitats in Colorado. So that's why it's the least preferred location and why we had extensive conversation about alternative locations. And so I think that's part of the reason why, you know, the word fragmented shows up 36 times in the SPP and 5 times in the actual oil and gas rules, because it is important. And so a lot of the conversation I did have with Summit was, you know, if it can be closer to the county road. So if you can imagine, county roads have like a 400-meter buffer or whatnot that pronghorn may generally avoid. So that overlaps with any potential new oil and gas developments.
Thanks, Mr. Moret. And if you wouldn't mind staying on the line, I have some questions for the operator. Mr. Chair, I wanted to pause there in case other commissioners had questions for Mr. Moret.
Other commissioners with questions for Mr. Moret? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Moret, for being here. So I'm just trying to better understand your perspective, and I want to, you know, I appreciate your, you know, the fact that you expanded on your thoughts around kind of center of sections and why they're important to this particular habitat and the importance of high priority habitat. I guess, so I saw in the timing steps and the recommendation in the wildlife mitigation plan, you know, as well as the presentation, a commitment to only have 1 trip a day for site visits to location during the timing stipulations between January and April. I'm trying to understand why you think that is important to minimize when you seem to be okay with, you know, every day being 15 to 90 heavy trucks entering and leaving location.
And so to clarify, that's 15 plus trips during the winter season or during the non-winter seasons?
Both, every day.
Yeah, so I think I was not fully aware of that during consultation. So like you said, there was that 1 trip a day, so that's news.
Does that seem to be problematic to you to have that level of heavy truck traffic? I mean, realizing that you're going to have a minimum of 15 trucks in, 15 trucks out, 30 trips. And during early production on this, you're going to see upwards of 90 trucks or 160 round trips during the timing stipulations for pronghorn.
Yeah, it is not ideal for sure.
Okay, thank you.
Does that change your overall analysis, Mr. Moret? I mean, not to put you on the spot, but
yeah, no, I mean, and you need to, because I'm a wildlife expert, so I appreciate that, Chair Robbins. And
yeah,
so,
and you know, I went back and looked at the rules, and they specifically say that in this instance, we really are to rely on CPW to make the calls as to whether a combination of compensatory mitigation and overall BMPs sort of right the ship or not. So that is why we look to you. And I you know, none of our jobs are easy, but I appreciate your willingness to stand up and speak with us.
Absolutely. And, you know, one of the options that we did discuss with Summit for the longest time is for them to have winter drilling and construction and production. Does he have that option to drill in the winter months? And if they did choose that option, then they would have paid CPW more mitigation dollars. But that, in my mind, even though it meets the bare minimum of the wildlife rules, in my mind, being in the middle of the section plus winter work didn't demonstrate to me personally that it was protective of wildlife resources. And so that's why we had this 11th hour call to have it cross that threshold that it is, even if it's on the lower side of protected wildlife resources, it is still.
Further questions for Mr. Moret or Commissioner Ackerman? If not, do you want to have some questions for the applicant? Commissioner McGowan.
Thank you, Mr. Chair. Thanks for being here today, Mr. Moret. Is there also a buffer around oil and gas locations for the pronghorn, similar to a roadway?
Correct. Yeah. So any disturbance, we look at about a 400-meter buffer. So
okay.
if you can imagine, those Weld County roads have a 400-meter buffer. You know, they mentioned, you know, that development to the south, and also that crude terminal to the north. You know, we consider all those to have some level, you know, roughly 400 meters of buffer. So that's why I try to overlap those 400-meter buffers to be as close as possible. And we had conversation with Summit as far as to shorten that access road to as much as possible, because the new access road is going to have a 400-meter buffer, indirect disturbance for pronghorn, and as well as the pad itself. So overall, you know, my goal is to maximize the amount of unfragmented habitat.
Got it.
Both
okay.
direct and indirect.
Thank you.
Commissioner Ackerman.
Thanks, Mr. Chair. I'm happy to proceed unless there are further questions for Mr. Moret.
I don't see any, but Mr. Moret, if you don't mind sticking around, that would be outstanding. Commissioner McGowan has a follow-up.
Sorry, thank you. So, and again, I'm not trying to put you in the hot seat, and I think there was some consideration or contemplation about this in your consultation and some of the materials that were submitted. Is it less impactful if there were two different locations, but they were within the 400-meter buffer near the roads? So, I mean, you know, here we're doing the yin and the yang of what the commission tries to look at when we're talking about minimizing impact, right? And so if you have two locations, but they're within the 400-meter buffer, which the pronghorn are avoiding anyway, is that less impactful than one location in the center of the unit?
Yeah, and that was, thanks for that question. That is something we did discuss with Summit, and no, CPW doesn't prefer two locations over one, even though, you know, 6 1/2 a dozen, you know, there is that, there's still impacts. And so, and I think I've always tried to, in my consultations with operators, you know, let's start with avoidance. Can you first avoid the HPH? And it's not possible in this one. So how can you minimize it to the extent possible? So that's why I'm glad that Summit agreed to avoid, you know, constructing and drilling and those completion activities during the non-winter months.
Okay, so thank you. I think what I hear you saying is it's not any better to have the two separate locations within 400 meters of the roadway versus one location in the middle of the unit.
Correct. Yeah,
okay.
Because in ECMC's web mapper, there is that greater than 5 locations, active locations per square mile. That's we also rely on too. And so, you know, part of my job is to make sure that that doesn't continue to spread more and more into high priority habitats. So in my eyes, having 2 locations would help that location, especially with the 2 eastern locations, get closer to that greater than 5 density threshold.
That's helpful. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. And I apologize, Mr. Moret, but I'm trying to understand your perspective here. So I understand that that the operator has agreed to timing stipulations for construction, and I'm assuming that your desire to see timing stipulations associated with construction and drilling and completions has to do with heavy truck traffic associated with it, lots of activities in an undisturbed area, and disturbing the pronghorn during the winter months. And I'm trying to make sure that you understand that what's being proposed in this particular application is not a construction activity that's being anticipated, but a production activity that's being anticipated in addition to the construction, completions, and drilling activities of, 15 to 90 heavy truck trips a day one way, right? So round trip, double that individual year round for the life of the wells, right? And so I guess it's confusing to me why you think it's important to have the timing steps for the construction, but you don't seem to have concerns about the truck traffic associated with production that goes on for the life of the well.
Yeah, and thanks for that clarification. And you can definitely tell in my testimony that this OGDP is right around that threshold of, is it protected wildlife resources? And so, like I mentioned, Commissioner Messner, it was my understanding that they were going to have it no more than once per day in HPH. And so, given that that's news to me, it keeps pushing it back on the other side of the threshold. And I'm not sure if, maybe someone from Summit can talk about that further, or maybe that's already a point, but that does make it more impactful for wintering pronghorn.
Okay, thank you.
Commissioner Ackerman.
Thank you, Mr. Chair. And I guess then my first question would be to Summit, give them an opportunity to respond to that point associated with truck trips. Commissioner Messner, if that's okay with you.
Yeah, thank you. So, WOBLA did disclose total truck trips in our WOBLA, 50 to 70 trips per day in full development. I don't recall specifically talking about those exact truck trips with Brandon. Citing this was threading a needle. When it comes to the HPH regions, like native species, right next to that, R115. We continue to work through midstream options, trying to induce midstream pipelines here. I do not believe that we will have that much truck traffic in full development over the life of this pad. I just don't, because we aren't trying to spur these pipelines. We do want to be in pipeline.
And this is Sam, if I just might add to that, just so the commission knows, we were not hiding truck traffic from CPW. We have always been transparent that liquids pipelines are something we're pursuing heavily, but are not an option, and thus product would be trucked. And we discussed traffic heavily through the WOGLA process. So I just want this commission to understand that we have not been trying to hide that from Brandon.
Yeah, and I appreciate that. I don't think that any of the commissioner's questions are influencing that perception, Mr. Bradley. But at the end of the day, and I appreciate your testimony, Mr. Pitsley, but at the end of the day, we're being asked to review and make a determination with the consult from Mr. Moret on the application as submitted, which includes truck traffic. And, while it's aspirational, and I totally believe you that you'd like to induce pipelines to be there, that's not part of the application right now. And so, you need to be aware that you're asking us to, I think what you even just admitted is threading, making a tough call. And the only thing we can do is make the call based upon the application, which is based upon trucks. If you, want to take it back, reconsider, think through it a little bit more, that's your call. And I'm not trying to cut off debate and dialogue. We can spend the rest of the afternoon doing that, and we're real good at it. But I just kind of wanted to sort of set the framework for what you're asking us to consider. Commissioner McGowan.
Go ahead.
Thank you, Mr. Chair. Mr. Bradley, I'm wondering, so since you've reconfigured and rethought about how many tanks you would need, and we're down to 24 now instead of, I think it was 48 before. Is that going to change your estimate of truck trips, or will you still need the same number of trucks even though we now have fewer tanks? I mean, I'm hoping that by reducing the number of tanks, you're reducing the footprint. I don't know if you're still going to need the 18 acres for the pad, that maybe that's going to be smaller, but then also, do you now also need fewer truck trips because you're going to have fewer tanks that need pickup to be picked up from?
Okay, this is Sam. Thank you for the question, Commissioner McGowan, and the follow-up on threading the needle, Chairman Robbins. The maximum anticipated truck traffic that is submitted with this application is assuming full development at time 0. Okay, and when we got the commissioner questions and we zoomed out on tanks, we thought, how can we minimize tanks, which thus also does minimize daily truck traffic? And what we came up with was slowing development. And so if we don't drill all 16 wells at once, and we don't get that bell curve of peak production hitting at the same time, we do not need that number of tanks we initially submitted, and also would greatly reduce the maximum daily truck traffic. And just as a follow-up to Chairman Robbins' comments on threading the needle, we've looked at this from a million different ways, and we also have to weigh all the different priorities. The couple houses that are around, the mapped wetlands on the east side, the sage grouse area that's further east, and effectively draining the DSU and preventing waste. And so just to your quick comment, Chair, about, if we would want to take this back and think more, and we've gone through this a zillion different ways. It's either one centrally located pad or 2 different pads. That's the only answer here. And I hope that addresses your question. Yes.
Commissioner McGowan.
Thank you, Mr. Chair. Okay, so sorry, now we've opened up a can of worms. I apologize. So I think what I hear you saying is reducing the number of tanks didn't mean that you figured out a different setup. It means that does this mean that instead of drilling all at once, you're going to drill and then maybe have to come back and drill because you don't want to have all your production up front, which now I'm going to have to go back to Brandon, because sometimes I think when we're looking at trade-offs for wildlife, the preference is you one and done, come in and get it done so you're not disturbing wildlife. So I guess I didn't catch that there was a trade-off for asking if you could reduce number of tanks. Quite honestly, we haven't kind of seen this since I've been a commissioner. And so trying to just work through why it looks like this, or ways that we could work on minimizing. So am I understanding then that you wouldn't be able to drill all at once, you'd have to come back in and in order to minimize number of tanks? And then if that is the case, I guess I would want Mr. Moret's opinion about whether or not he would prefer the original setup then instead.
Thank you, Commissioner. Yes, we are contemplating more than one visit. I would also add to the tail end of Sam's comments. Look at what we've done on DSU 11 and 12. Even though we've been permitted for far more tankage, we've set far less. There's a slow pace of development. When you step back and you look at the day count between construction, drilling, completing, flowing these 16 wells back all at once, and you look at the documents we provided, you'll sum up to roughly 318, 320 days. committed not to doing any construction, just drilling and completing. January 1st through April 30th. Well, that leaves us 245 days a year. So clearly we can't do a single rig visit. Separately, and then importantly, proposed location will require a total of $145 million to develop. Summit's financial sponsors know what the future will hold. So we can't commit to a single development of that magnitude. And so we permitted this pad to maximize our, I'm sorry.
I'm sorry to interrupt, but I want to make sure I'm understanding what you just said, which was the original application did not contemplate one single drilling and completions all done, one and done. It also had phases. Is that what am I understanding correctly?
Yes, Commissioner. If we look at the 2B, and I apologize, I don't have the row that it's on, but we did indicate up to 16 visitations, one for every well. That was merely to maximize the flexibility.
Oh, okay.
And as our just to finish that thought, as our financial sponsors accumulate dollars, we move forward with development. This is what we've done on DSU 11, DSU 12, which on the plus side means that they don't utilize debt or anything of that nature on these properties, which actually lessens the likelihood of orphan wells in, let's say, a low crude environment or a high interest rate environment.
Okay, so I'm going to try to summarize what I think I heard because I want to make sure I'm understanding correctly. And I don't know how I missed this, so this is on me. The application, as it was submitted, contemplated multiple, I don't know what the word is, I'm like multiple drilling phases. Even if we kept that, you are now able to commit to fewer tanks with that setup. Okay. But what I also hear you saying is one and done is not something you all can accomplish. And it would affect many things. Okay,
correct.
Thank you.
You're correct. One and done is not something we could accomplish.
All right, Commissioner Ackerman, I believe, has been waiting to have some questions.
Thanks, Mr. Chair, and I very much appreciate the follow-up on those issues while they were at hand. So thank you to my fellow commissioners. I again continue down this same line. I think there have been a lot of conversations, a lot of good things that this operator has done. I do think wildlife remains the primary concern here, and you know, from my training and experience as a wildlife biologist, I as well know the importance of the center of sections on the Eastern Plains for pronghorn, especially in winter concentration areas. And so I'm trying to find a way to make this happen that's less disturbed. And I know that's something that you all have had a lot of thought about. When you brought the ALA map up, I noted that ALA, you know, the location E on the, clearly to me, you talked about locations A and B and C and D, and those were clearly illustrating significant modifications to operational procedures. They were, you know, located at the far end of the DSU, or towards the, you know, 2/3 end of the DSU. To me, from an operational standpoint, looking at alternative location E, which was the location that was still centered in the section vertically, but was on the eastern edge near the county road, felt more viable. So I wanted to talk a little bit more, and I know that you've explored that significantly. Wanted to talk a little bit more about that. I noted first that there was no corresponding proposal on the west side. I'm presuming that it's because there's an RBU somewhat nearby. So that's my first question. Are there other reasons, or was it associated with that RBU?
Well, yes, it's associated with the RBU, but it's also associated with the step outs distances that Sam had discussed from an engineering standpoint in a low GOR environment. I also point out with E, it puts us 520 25 feet from the aquatic native species.
Yeah, understood. My question was because there was one proposed in location E, even with the step outs. There was not one proposed on the west side that was corresponding. And so the step outs wouldn't be the same reason that you wouldn't do it. But I do understand that the proposal maybe was associated with that RBU.
That's correct. It would be within 2,000 feet of the RBU on the west side.
Gotcha. Okay. And so then I wanted to talk a little bit more about those step outs. And admittedly, this is out of my depth. And from an engineering perspective, we've had significant discussion about this before. And I think I heard you mention that there are other DSUs where it does have some pads on the far east or the far west of the center of the DSU, and that those have longer step outs and that you've learned from them. Did I mishear that, or was that an accurate statement?
Thank you, Commissioner Ackerman. This is Sam, and I would refer you back to slide 3 that shows the COGCC outline. The simplest way to answer that is our Castor 11 pad that's 2 miles directly east of this proposed DSU. And when that pad was permitted in consultation with DPW, that pad was moved to the far west side of the DSU to move it further from the sage grouse. And as we have learned from drilling and completing and producing in this area, we realized that reaching the far east side of that DSU from the existing location is going to be tough or undoable at this time. And we actually released those permits with the significant mile-long step out for the wells on the far east side of that DSU as a result. Does that answer your question, Commissioner?
Yes, partially, Mr. Bradley, only because I haven't asked the other part yet, but thank you, I appreciate that. So the follow-up to that would be, that's your example, but it's not one that's already been attempted. It's that you've found in your analysis that you're not going to do that. Is that correct? As far as drill to the other side of the DSU.
So what we learned from that is if we were forced to put a location on the far east side or far west side of a DSU, we would need 2 locations, one on each side, instead of one, to fully drill and drain the DSU. Does that answer your question?
I'll be more direct, thanks, Mr. Bradley. So in that one where you've put it on the far west side, have you actually drilled wells to the far east side, and then you've said we don't want to do that again?
No, we drilled halfway. We drilled essentially down the middle of the DSU, and we ran dissolvable frac plugs at the toe of the well, and we had issues drilling those plugs out, and we did not have gas energy to help us clean the hole, and we realized we'd pushed the limit.
And that was at about halfway across the DSU.
Yes, sir.
Thank you, that's helpful. Switching to mitigation, I also noted that you had discussions in the wildlife plan about mitigation, and that you selected option 2 in the wildlife plan as documented, which has a specific mitigation figure associated with it. But option 2 is precluded by what's in the 2A. And so I just wanted to clarify there that the 2A mitigation option as far as compensatory mitigation is trumping the wildlife plan that sets the figure at $198,196. Is that accurate?
Sorry, one more time?
In the wildlife plan, compensatory mitigation that was discussed with CPW contemplates the wind. Go ahead.
Sorry, Commissioner. This has been about a 1.5 long process, and
sure.
We've met with Brandon a few times. So what occurred was we had computed a compensatory compensation plan around Christmas of the not last year, the year before. And then through the completeness process, we realized that we had Number one, the incorrect acreage when it comes to stockpiling being included in long-term or not. So we had a small issue there. And then through a discussion we had with CPW around some of these mitigation plans, specifically the months and the visitations, noise levels, Brendan and his team went back and did a computation and provided us as a proposal that was submitted as part of this application. So yes, what Brandon had recently submitted trumps what we would have provided originally in the 2A that went into completeness, and then we met with Brandon a final time. If I've spoken out of turn, Brandon, I would ask, or Commissioner, I would ask Brandon to please correct me.
Thank you, Mr. Pitsley. And then before we do that, do you know what figure you arrived at then? That would be the figure that we would be approving?
It in here.
To help out a little bit, what I'm seeing is the temporary and permanent disturbance adding up to about $98,512, and then additional disturbance outside the pronghorn winter season would be an additional $56,962.50. So whatever 90, approximately, 154,000-ish, as opposed to the 198,000-ish. Does that sound right?
That's correct. It was roughly 25% lower. I would, if I may, Commissioner, point out, and again, I would ask Brandon, correct me if I'm wrong, if his memory is different. When we met on location, proposed location originally, we were unaware that this payment could occur, and so we had a good discussion with Brandon. And CPW did state that we had the choice to either participate in a program, an investment of some sort, in a project, I think is what it was called, or go the compensatory route. And I did ask, were there any projects, and at the time there were not. And so we did just go the route of payment, and we.
Thank you. I appreciate that. And I don't know if Mr. Moret has any clarification there.
Yeah, and thanks for that opportunity. And yeah, for the longest time, I was really focused on alternative locations, both when it went through the WELA process and ECMC's process, as far as, the preferred locations. So we were focused on that. And like I mentioned from the outset, they do have the option of impacting the pronghorn winter season and paying the higher amounts. But like I mentioned earlier in my testimony, that did not appear to me, between that and being in the middle of a section, that is protective of wildlife resources.
Thank you. I appreciate the additional testimony there. I think that's all I have for now, other than to follow up with Mr. Moret. Given this conversation, Mr. Moret, I know you've been asked a couple of times about your point of view, and I just wanted to solidify my understanding of your point of view, and that is that one location in the center is preferable to two locations on the edges, and that your calculations took into account the potential disturbance that's being mitigated by not having construction, drilling and completions during the winter pronghorn closure period of January 1st through April 30th. But then there was significant discussion about significant truck trips that sounded like it wasn't necessarily part of your original calculation. And I wanted to clarify, given the time to kind of masticate on that a little bit, if you can just clarify for us where you sit there.
Yeah, and I appreciate that. And my apologies if I didn't catch it earlier, and I appreciate Messner if I'm flip-flopping a little bit on the topic, but I am concerned on page 6 of the director's recommendation about how the operator and contractor agree to restrict well site visitations to no more than once a day. Hearing how it's different, I'm trying to work to yes on this permit, but seeing that number of truck trips is concerning to me. So I'm open to discuss that right now with Summit, but that would be my ideal preference.
Your ideal preference would be meaning that once
Trying to get to the once per day, as we had previously discussed and is in the director's recommendation.
Understood. Thank you. And so then my follow-up, Mr. Chair, if I might continue to the operator, is if we talk about, visits of once per day, and we're talking about the amount of water that needs to be moved, is that is that a solution that you can work towards or no?
Mr. Bradley, Mr. Pitsley.
So this is Sam. I'll take it, and I appreciate the discussion. We have been consistent with through both the county permitting process and the state permitting process that at this time, oil and water pipelines are not an option. But we will continue to push the subject hard, and it is our belief that as development in this area continues, that solution will arrive. To me, this is kind of a miscommunication where on our other permits, visitations have been referring to pumpers, but not trucks hauling product. And so as oil and water pipelines are not an option, we cannot commit to one truck trip per day. It's not feasible.
Can I add to that? And we may, when Brent here in operations, just going to the math and looking at how we arrive at some of these numbers using the 2B. So I think, again, so we're, I guess, all thinking about the same information. The flush production of 16 wells would result in a large amount of truck volume that discussed. After the first 120 days, 16 wells at once, we're looking at 0.8 to 1 truck visit per well. So I just want to make sure that we're on the same page as we're discussing these numbers again. All 16 wells at once, no, is not possible. You need at least 2 rig visits per program.
And can you summarize what Ben is saying? Ben's cutting out at the beginning and the end of every single sentence, and it makes it really hard to follow.
Sorry. Computer screen's in my right here. Okay, so what we're trying to explain is making sure that we're all on the same page when we're talking about these numbers, these truck trips. So the large numbers, the large trips, 60 a day for the first 30 days, then 40 for the next 30, then 20 for the next 30. That's flush production out of 16 wells. We've already talked about an inability to bring on 16 wells at once. So I would break that down per well, which is in the first 60 days, or first 30 days, you've got roughly 4 loads a day, which would occur, let's just say in the summertime or fall, followed by the next 30, which is about 2.5 loads. By the next 30 days, another load and a half, followed by on 4, we're looking at about a load a day per well, based on our batteries. And so based on our plans and the discussions or the points I've tried to make regarding our financial sponsor, our inability to do a single visit, we are not, I think it would be erroneous to think that we are going to be capable of hauling off 60 loads a day from this pad. I don't think that's realistic. It's not realistic. It's just, we can't even bring on 16 wells. And again, since that's flush production, the first 3 months, that's not going to occur from January through April. It won't. So I think it's more reasonable to say we're looking at a load a day on average per well. And think about it per well. Then to Commissioner McGowan's comment about opening a can of worms, you then step back and look at truck traffic, which we've broken down on rig visits, which is far lower than this production out of 16. And did you have anything else to add to that?
No, I think that covers it. And we just know from our two pads we operate that, you know, we are hauling less than a load a day per well after roughly 90 days. That we don't anticipate being anywhere near 60 loads a day without developing the whole unit, which, as has been said many times, we cannot do.
And I would also add that's year one, right? So the way the 2B is asked is what's the remaining year loads, right? So when I say it's a load, 0.8 is what we have, but let's just say it's a load a well for month 3 through 12. Month 13 through 24 is lower. Every day a well produces less than it did yesterday.
Can I make a statement and or a suggestion? I think you've seen that the commissioners as well as Mr. Moret are struggling with, you know, these numbers, and all of this is quite important to get right. So the commissioners are in a place to be able to, you know, fully sort of make a full deliberation on this. And I appreciate the stuff you just threw out there. But I'm almost thinking, at least for this commissioner's lame head, that we need to continue this for just a small bit to give you a chance to fully sort of develop this operational structure, what the trips are going to potentially look like, why they are X versus 15 to 90, which is what we're kind of dealing with right now. And I'd love to give you an opportunity to further discuss this with Mr. Moret. And I'm sorry, I'm creating more homework. And I may just be one commissioner thinking along these lines, but I truly don't believe I'm going to be in a place to be able to vote yay or nay. And if I'm forced to vote, I'm probably going to vote no. What are other commissioners thinking? Commissioner Messner?
Thank you, Mr. Chair. I mean, there is certainly some confusion here, but it also appears to be, at least from my perspective, a little bit of fuzzy math that's happening here, because there is contemplated 16 wells on this location. And at some point, based on the application, even at one load a day per well, there's going to be approximately 15 truck trips per day, round trip, 30 individual trips. And that's, I assume, in the foreseeable future. So, I mean, I don't imagine that you anticipate completing this location 20 years from now. And so at some point in the foreseeable future, as is indicated in your transportation plan that you submitted as part of this application, the standard minimum amount of truck trips associated with full drill out of this particular location is going to be approximately 15 truck trips a day. And so while I appreciate that, you know, some initial volumes of that you may have indicated in your transportation plan are upwards of 90 truck trips a day from your transportation plan, that does anticipate, as you'd indicated, full build out. So I understand that, but it's also probably, as you anticipate having, what I'm hearing is potentially 16 occupations of this site in order to drill individual wells as money allows, that there'll be different wells in different stages of production, which doesn't change the ultimate minimum amount of truck trips associated with this to be approximately 15 truck trips a day. And so while we certainly can go back and, you know, have a further discussion on that, I'm not sure there's any way to get away from the fact that there's a minimum of 15 truck trips a day associated with this site upon build out, which I anticipate that you intend to do because that is part of this application. And so Mr. Chair, understanding that, I'm certainly prepared to, continue to ask questions and deliberate on this because I'm not sure, even with time, they're going to be able to come off of that number.
Maybe I would ask the applicant if they'd like to respond to either of the thoughts just echoed by myself and or Commissioner Messner.
Sure, this is Sam. I'll go first. And Commissioner Messner, I can understand how things get fuzzy and confusing as we start contemplating, 1 rig visit versus 16 rig visits. What I can say is our math and our disclosures and our truck trips and our emissions and our rig mobilizations were complete and accurate as submitted in our 2B and our transportation plan. So yes, when we get in a group and we start saying, well, what if you do these many modes and what if you do these many modes, it does get confusing, but it doesn't change the fact that whether this location is at the proposed site or on the east side or the north side, no pipeline and the product has to get to market. We're fortunate that the crude terminal is a couple miles away and multiple disposal wells are also in close proximity, and we're not trucking across multiple counties through high density population zones. But regardless, product has to get to market. And so to me, it is what it is. And I think Ben might have some comments.
Yeah, I would just add the scenario analysis and the what ifs around development, something we do at EMPs, companies. And it's an ever-changing process. And our financial sponsors naturally would like to bring everything forward in time as quick as possible. I think that by slowly developing this, that initial large flush production that necessitates a massive amount of trucks is not in our future. Yes, in the long run. Without pipe, we're going to look at 15 trucks per day. That is to Sam's point. And we can't get away from project, again, without pipe. Anything else?
No, I think you covered it.
It's about smoothing the initial bump.
I appreciate the idea of taking more time to talk to Mr. Moret more, but the story's not going to change. I mean, the reality is the reality. The product has to get to market.
Let me add to that.
And this was very thoughtfully and completely discussed and disclosed as we worked our way through the WOGLA process.
To add to that, going back to my comment about scenario analysis, I mean, we could bookend it, and we bookend it with initial truck traffic at 16 wells all coming on at once within the 10 loads a day. And then on the other side of the bookend, it'd be 3.75 loads per day, the first 30 days. And I've already talked about by 4, you're at 1 load per day, which would fit with W's Commissioner Messner, 1 well.
All right. Commissioners, further questions for the applicant? All right, seeing no further questions, perhaps we will move to deliberations. I think before we do that, let's take a few minutes. I know I could take a few. Let's return at 2:25. That's about 6 minutes out. All right, before we move to deliberation, I'd like to recognize Mr. Willis to see if he has any final thoughts for us.
Thank you, Chair Robbins. When we went black, we did have a conversation regarding this concern regarding the truck traffic. And what I'd like to do is have Mr. Pitsley again. He's got one more chart, which I think is helpful, that he'd like to throw on to try to at least let you know what he says or what his expectation for truck traffic or loads from the location would be. So if I could just defer to him.
Okay.
I appreciate it. This will just take a minute. Because like most people, I'm more interested in graphics. I mentioned bookends. These are the bookends of the loads that we filed in our 2B. And so what you're looking at is 1 year in orange, full development truckloads per day. 15 wells all at once. Said that was the high side. On the low side, on a single well basis, is in green. The hard code numbers are right on the left there if you want to see those. So when I say bookends, this is what I'm talking about. We arrive at that roughly, it's 12 and a half, call it 15, whatever loads a day, long term, single well basis, there's your single well. So this flush production is not possible because it's one rig visit. We would end up landing on this project would be somewhere in the middle. Based on our history with a financial sponsor, I'd say it's on the low side, not the high side. You can see what we've done on DSU 11 and 12. So if there aren't any questions, this is all I wanted to show. Okay.
And this ties directly to what we submitted.
And this ties, yes, directly to what we submitted in our 2B.
Questions from the commissioners? And just pipe up. I can't see it because I'm looking at his bookends. All right. Thank you. All right. Well, thank you very much, Mr. Willis. Thank you, Mr. Pitsley and Mr. Bradley. We appreciate the presentation today. Commissioners, we now move into deliberation or process or next steps. Does anybody care to weigh in? Commissioner Ackerman.
Thanks, Mr. Chair. I'll kick this off. And admittedly, as per the discussion here today, and as we've seen, this is a difficult one and was difficult for me upon reading it. And I also don't want to say that because it was difficult for me, it wasn't difficult for the operator. I think they struggled probably more than I did trying to get to approval on this for sure. And like I mentioned when I started my comments, I think there are several good things about this application. I think it's clear that they've made an effort to do what they can to minimize impact to wildlife. And so what I'm going to talk about here isn't an indictment on this operator, but rather a discussion of the situation that we all find ourselves in here today. And I think, we're focused on pronghorn winter concentration, HPH here. And to be clear, generally the recommendations for pronghorn winter concentration high priority habitat are, and keeping in mind that high priority habitat recommendations go out much broader than to this commission and to operators of oil and gas, but rather to local governments and to everybody that CPW comments to. And they generally state no permitted or authorized human activities from January 1st through April 30th. And so activities is much more broad than, construction and drilling and completion. But historically, we've worked with oil and gas companies to be able to figure out how to make things work. Because often oil and gas companies are working in wildlife habitat. And in this case, and further with high priority habitat and winter concentration areas for pronghorn, generally CPW recommends no more than 1 pad per square mile, less than 1 mile of linear routes per square mile. And you can see that this development does comply with some of those, and certainly also complied with a portion of restriction during the pronghorn winter concentration area. And then there's a point in CPW's HPH habitat document that talks about that mitigation can be implemented if, like we mentioned, it can't be, effects can't be avoided. My largest concern, and I think has come out in part of the discussion, is certainly the development in the middle of the section. And I wanted to expound on that just a little bit. I know the operator stated it's a disturbed area because there are roads surrounding the section, and that's not the case in some other sections. That, all sections in eastern Colorado don't have roads on all 4 sides. Sometimes there aren't roads separating sections, as alluded to by Mr. Murat. But in this case, there are roads around the entire section, making this, a smaller portion of pronghorn habitat, and covers one of the 4 imperative parts of their habitat and their well-being. And so a cover is, if you see a mouse and it sees you, it might run in a hole. If you see a squirrel, it sees you, it might run up a tree. Deer will often escape into the woods. Pronghorn are different than pretty much anything else. Pronghorn cover is open space. And, pronghorn can see 8 times like they're looking through an 8-power scope in 300 degrees. And they can run faster than any other land mammal in North America at 60 miles an hour. And so their cover essentially is being able to see the threats coming and run away from them. And so pronghorn are particularly sensitive to threats coming their direction, and they do tend to run. They do get accustomed to traffic along regular routes, but as soon as that traffic turns off regular routes, you'll find that they often run. And so the center of sections, as we talk about escape cover in eastern Colorado, is really generally the best escape cover habitat for pronghorn. So we're not just talking about part of the HPH here, although we're talking about arguably the best escape cover that pronghorn have in eastern Colorado on a more general basis. I find myself in a conundrum because I believe the operator when they state that technically it's not possible to drill further in this geological formation than halfway across the section. We've tried it. We had struggles. We even stopped our operations halfway through a previously permitted unit. That is compelling to me. We're not trying to keep operators from developing resources here, but we also have within our mission to protect wildlife habitat. And so to me, it puts us all together in the same conundrum here. And I boil it down to our decision here today, to me, really speaks pretty strongly toward this commission saying, okay, we're going to allow development right in the middle of the one most important components of one of the most important pronghorn habitats in eastern Colorado, or we're going to say, absent midstream pipeline development, those places are currently undevelopable, right? And again, I'm strongly generalizing that, but to me, it kind of sets that conundrum for us. My preference certainly would be to find a way to move the pad closer to a county road. I believe that pronghorn, from my experience, would be able to coexist if the pad wasn't in the middle of a section. I don't have a crystal ball, but from my experience, my over 20 years of experience, I suspect that putting a well in the middle of a section surrounded by 4 roads would make that pronghorn habitat generally unusable by pronghorn if we're talking about the number of truck trips that we're talking about. So again, I don't have a solution here. I'm outlining the conundrum. I'm inclined to continue to talk about potential solutions. I hear the operator saying, I don't know that we have some. I respect CPW's approach to 1 pad over 2. And this operator, as they talked about, is trying to develop a larger subsurface space with one pad in this case than is normally developed. I certainly would be open to further discussion about pads closer to the county road. Again, respecting and recognizing CPW's recorded statement that they prefer one pad to two. So, Mr. Chair, I don't know that I'm ready to make a decision, but if we are moving towards a decision today, I do think it's going to be difficult for me to approve an OGDP that, you know, is set right in the middle of one of the most important components of one of the more important habitats for pronghorn.
Thank you, Commissioner Ackerman. I think your fellow commissioners appreciate your background and expertise in dealing with these issues. Commissioner Messner.
Thank you, Mr. Chair, and agreed. Appreciate your perspective, Commissioner Ackerman, and your expertise in this particular topic. I'm going to talk a little more just about the application itself and the different rules that I apply as I'm evaluating this particular application. I think Commissioner Ackerman clearly kind of highlighted the conundrum that this application kind of presents. But, you know, as indicated by Commissioner Ackerman, I think the primary concern with this OGDP for me is wildlife. And as with all OGDP reviews, the applicant has the burden of proof to show that they have appropriately applied the mitigation hierarchy and made a showing that they are protecting and minimizing adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and are protecting against adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations. These are requirements that are in Rule 301A, 307A, Rule 304C19, Rule 1203, Rule 304B2B, Romanet 7, Colorado Revised Statute 34-60, 103, 5.5, as well as in other parts of the rules. It's important to note that as amended by Senate Bill 19-181, Section 106 of the Act provides that in exercising the authority granted by this Article 60, the Commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and shall protect against adverse environmental impacts to any water, air, soil, or biological resource resulting from oil and gas operations. This is Colorado Revised Statute 34-60, 106, 2.5A. So thus, in addition to using the defined term minimize adverse impact, the revised version does not include the phrase cost effectiveness or technical feasibility. And to me, this is going to be a root of how I applied the rules to this particular application, is that it does not include the phrase cost effectiveness and technical feasibility. So the facts of the case as I see it, and I want to start with some things that are really good about this application. I think there is a lot that is good about this application. I think the applicant is proposing Group 3 drilling mud. I think the utilization of dual fuel drilling rigs with a battery backup, Tier 4 quiet fleet for completions, electrification of the site, air monitoring, a timing stipulation from January to April for construction, drilling, and completions. I also appreciate that they did agree to a timing stip for site visits to once a day. I think there was some confusion as to what ultimately that meant, and I do understand that there's some confusion there. But I do think that these things are really forward thinking by the operator as things that are good. But I think there's a number of things that are also problematic with the application. I mean, this is a new surface disturbance that is in the middle of a section, as Commissioner Ackerman talked about. It's almost 23 acres with interim reclamation to just over 16 acres, which is a really big footprint. initially there was proposed to be 48 oil and produced water tanks, which is a pretty significant number of tanks. I appreciate that it was contemplated to be reduced to 24 at hearing today. The location is sited in the middle of an undeveloped section, somewhere between 1.5 and 2.25 miles from a county road. It was a little unclear to me in the application because there was different numbers in different places in the application as far as how many miles it was from the county road, but all of this would require additional new surface disturbance to put in the approximately 2 miles of access road. The location is both within mule deer and pronghorn high priority habitat, with pronghorn being the most sensitive in this location. And while the location will be tied to a gas pipeline, which is appreciated and required in our rules, the oil and produced water are going to be trucked for the location for the life of the wells, as applied for in the application. I also understand that there's a desire by the applicant to be able to tie into produced water and oil takeaway. But if we approve the application as submitted, it would allow for that trucking to occur through the lifetime of the well, which, as I indicated before, at build out would be at a minimum 15 truck trips a day as indicated in the transportation plan, and certainly could be more than that. I understand that there'll be 16 different occupations of this site to drill. And so it's a little hard to know at this point what we are going to see for truck trips. And so without having a clear determination or schedule of exactly what the construction timetable would be, we have to assume that what's being provided in the transportation plan is somewhere between 50 and 90 truck trips a day. CPW indicated in its review that it doesn't believe that this site minimizes the amount of habitat fragmentation in high priority habitat area. They have stated that activities closer to existing land disturbances and roads would be preferable. And there is clear evidence of habitat use, I think as highlighted by Commissioner Ackerman. As presented within the, as Commissioner Ackerman stated, it's a conundrum, but I'm afraid that currently in this commissioner's opinion, that the applicant in this OGDP did not meet its burden of proof to show that the application meets both the rules governing oil and gas activities in the state or the rules offer a number of opportunities for applicant to make a showing that is properly applying the mitigation hierarchy and proposing operations that are protective of wildlife and wildlife resources. Examples of these opportunities would be in the cumulative impacts plan, the wildlife and compensatory mitigation plans, and the alternative location analysis. But before I get into the deficiencies in the submitted plans in the application, I want to highlight how I'm looking at this with some references from the definitions of the rules, the act, and the statement of basis and purpose. And I do this to create a clear record so that folks do understand how I'm approaching this. I looked really hard at the definitions of avoiding adverse impacts, which means to differentially select alternative locations, practices, or methods for oil and gas operations based on site-specific circumstances so that these operations will not cause quantifiable direct, indirect, or cumulative adverse impacts to a potentially affected resource. Avoidance may include a no-action alternative. There's a definition of the compensatory mitigation plan. And that's an important piece in 1203 on how to offset the direct and unavoidable adverse indirect impacts to wildlife resources from oil and gas operations. The definition of minimize adverse impacts is provided by CRS 3460-106-2.5 as providing necessary and reasonable protections to reduce the extent, severity, and significance of durations of unavoidable direct and indirect and cumulative adverse impacts in this instance to wildlife resources from oil and gas operations. To mitigate, the definition of mitigate adverse impacts means, with respect to wildlife resources, measures that compensate for unavoidable direct, indirect, and cumulative adverse impacts and loss of such resources from oil and gas operations. And so all of these highlight the term unavoidable adverse impact. And so the definition of unavoidable adverse impact means direct, indirect, or cumulative adverse impacts to public health, safety, welfare, the environment, or wildlife resources that are not entirely eliminated through the application of alternative location selection or other methods designed to minimize adverse impacts from oil and gas operations. And I want to highlight that wildlife resources means fish, wildlife, and their aquatic and terrestrial habitats used for all life stages, including reproduction, rearing of young and foraging, and the migration corridors and seasonal ranges necessary to sustain robust wildlife populations. I don't think it's a debate that this is not an important high priority habitat wildlife resource in this particular situation. And so back to the mitigation hierarchy. So on page 172 of the 1200 series statement of basis and purpose, it talks about the mitigation hierarchy. And it indicates that in implementing the clarified mitigation hierarchy, the commission chose to define avoid adverse impacts, minimize adverse impacts, mitigate adverse impacts, and unavoidable adverse impacts. That's why I went through those definitions. The commission believes that the additional clarity provided by these definitions will assist stakeholders in understanding how the commission will review proposed oil and gas operations. Importantly, the commission defined the term unavoidable adverse impacts to articulate how it would address those residual impacts that remain even after the commission has considered the opportunity and ability to avoid impacts and has included site-specific measures to minimize impacts. Again, in the statement of basis and purpose in the 1200 series on page 170, Senate Bill 19-181 modified the mitigation requirements appropriate for permit conditions in the Habitat Stewardship Rules, Colorado Revised Statute 3061-28-3B. Second, the legislation clarified the hierarchy for minimizing impacts from oil and gas operations by directing this commission to first avoid impacts, and then seek to minimize impacts, and finally to mitigate those impacts, which is Colorado Revised Statute 3060-103-5.5. So complementary to this hierarchy is SB 19-181 mandate to the commission that at a minimum, it adopt an alternative location analysis process and specify criteria used to identify locations that are proposed to be located both in populated areas as well as to the directive to avoid impacts on wildlife for wildlife resources. And so these are elements that I'm using as I evaluate this particular application and certain plans and submittals as part of this application. So one of the things where I struggled with is in the cumulative impacts plan. Cumulative impacts plans are required as part of Rule 304C19. In this particular instance, the cumulative impacts plan doesn't meet the burden of proof for clearly make a showing of compliance with the rules or the 304C19B requires operators to describe specific measures taken to avoid or minimize any incremental increase in adverse cumulative impacts. The commission intentionally used the terms avoid and minimize in Rule 304C19B, consistent with the definitions of those terms adopted in the 800, 900, and 1200 mission change rulemaking. You know, if you go back to the definition of avoiding adverse impacts, the application must first avoid impacts before it applies minimization or mitigation. And in this particular situation, the operator has not shown that it has appropriately avoided impacts. In Rule 304C19C, it requires operators to identify any measures taken to mitigate or offset cumulative impacts to any resource. The commission used the term mitigate adverse impact in Rule 304C16 in a manner consistent with the definition of mitigate adverse impacts adopted in the 1200 mission change rulemaking, except that the commission intends for the rule to apply beyond wildlife resources. Again, I want to go back to the definition I previously stated about the definition of mitigate adverse impacts. This definition clearly indicates that mitigation is an option only for unavoidable impacts, which the applicant has not shown to be unavoidable. The applicant confuses their attempts to mitigate with avoiding, but the rules, the statement of basis and purpose and act clearly show that it is not the same. In addition, the applicant continues to use cost effectiveness and technical feasibility as prime arguments in the plan, which are not allowances for review by this commission under the rules or the act. Now, I'd like to talk a little bit about the alternative location analysis, which is required as part of 304B2B Romanet 7. So in the statement of basis and purpose of the 1200 series, page 174, the use of an alternative location assessment is the primary means of achieving avoidance of adverse impacts. By differentially selecting locations which by their very nature have less impact on wildlife resources, the mitigation hierarchy of avoid, minimize, then mitigate can be effectively implemented. In my opinion, the narrative around the alternative location analysis in this application does not highlight or make a showing that meets the applicant's burden of proof on how it utilized the alternative location analysis to implement the mitigation hierarchy, but rather focused on the operations of the location and its economic and technical feasibility, which cannot be used as a consideration in our evaluation of locations. There was no showing of how the location chosen first avoids impacts to wildlife. It rather highlights how they will mitigate impacts that are avoidable. The location chosen is in the middle of an undeveloped section in high priority habitat with clear evidence of habitat use, which does not avoid habitat fragmentation or avoidable impacts to wildlife. In addition, the chosen site is not located adjacent to existing disturbances and roads, which is particularly important as the applicant is proposing trucking both oil and gas through high priority habitat for the lifetime of a well with a minimum of 15 truck trips a day. And finally, I want to talk just a little bit about mitigation. In the statement of basis and purpose, 1200 series, page 211, Rule 1203D requires mitigation of unavoidable adverse indirect impacts to the high priority habitats listed in Rule 1202D. This narrow approach to mitigation of only unavoidable adverse impacts appropriately prioritize avoidance first, then minimization, then mitigation, where avoidance and minimization are insufficient to meet the goal of sustaining a robust and sustainable wildlife population. Compensatory mitigation is not a tool, these are my words now, compensatory mitigation is not a tool to pay to play and shall only be utilized to offset unavoidable adverse indirect impacts. By choosing a location in this application that has avoidable impacts, I do not believe the compensatory mitigation is an appropriate tool solely for addressing impacts and applying the mitigation rather than applying the mitigation hierarchy. So finally, Rule 307B2 states that if the commission determines that an oil and gas development plan does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, the environment, wildlife resources, or fails to meet the requirements of the commission rules, the commission may deny the oil and gas development plan. So through the findings that I have previously indicated, I do not believe the applicant has met the burden of proof to show that the OGDP provides necessary and reasonable protections, does not properly apply the statutory requirement in CRS 3460-103-5.5 to implement the mitigation hierarchy, to first avoid impacts from oil and gas operations, and to minimize and mitigate the extent and severity of those impacts that cannot be avoided, does not, through the utilization of the cumulative impacts plan in Rule 304C19, make a showing to describe specific measures taken to avoid any incremental increase in adverse cumulative impacts. It does not properly employ the alternative location analysis in Rule 304B2B Romanet 7, in which the use of an alternative location assessment is the primary means of achieving avoidance of adverse impacts. Again, statement of basis of purpose, page 174 states by differentially selecting locations by their very nature, which by their very nature have less impact on wildlife resources, the mitigation hierarchy of avoid, minimize, then mitigate can be effectively implemented, which was not done here except by attempting to utilize economic and technical feasibility. And finally, the applicant attempts to employ compensatory mitigation avoidable impacts rather than unavoidable impacts as a mitigation tool, which is not allowed by either the rules or the act. So for these reasons, I don't think I can support this application as it's presented today. And those are my thoughts, Mr. Chair.
Thank you for the thoughts, Commissioner Messner. Other commissioners, Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioner Ackerman and Commissioner Messner for your comments leading up to this. I do find those helpful. And I will try and keep this brief so as to avoid duplication of many of your comments as well. I'll start off saying that coming into today, I honestly thought this would be a pretty easy application to approve. And the reason for that is in looking at the efforts taken by the operator, I think that a lot of work was done both in consultation with CDPHE and in consultation with CPW to try and make changes to an application to take a lot of efforts to protect a lot of the resources that are at issue here. And obviously wildlife has been one that we've talked about most, but when you also look at the area of the state and the emissions issues, the fact that they're doing the tier 4 completions, the fact that they're doing tier 2 with the battery assist and the dual fuel, I think that there's a lot of steps being taken in order to try and avoid, minimize, and mitigate those impacts overall. I think when it comes to the wildlife, I do want to acknowledge the efforts taken by Commissioner Messner preceding my comments that, yes, the definitions in our statute and in our regulations do talk about avoiding adverse impacts and where they cannot be avoided to minimize and mitigate those impacts. And to me, I'll just say, looking at it, avoiding adverse impacts means eliminating, as Commissioner Messner mentioned, eliminating any quantifiable direct, indirect, or cumulative impacts. Quite simply, that can't be done here. The entirety of the area being proposed to be drilled is within high priority habitat, in fact, numerous high priority habitats. And so there is no way to avoid those impacts absent no action. And so that leaves us to look at minimization and mitigation. And in looking at the consultation summary provided by Mr. Moret leading into today, I read that as saying, while not the ideal location, and he actually quotes to say, these wildlife BMPs demonstrate that the summit is minimizing its impact on wintering mule deer and pronghorn and potentially occurring plain sharp-tailed grouse. Therefore, CPW has no further objections or outstanding issues associated with this OGDP application. I think the testimony today has thrown a wrinkle into that. I'll be honest, in looking at the application, the one visit, the way I read it was for maintenance purposes, because I don't think there's any way in which you can look at it to say, if we're going to have to truck oil and produce water off site, that it can be done in that kind of numbers. It's just not feasible. And so I looked at it in that way. The fact that there now appears to be confusion as to what the one trip a day meant obviously seems to create a little bit more concern. And honestly, I was hoping to get a clear answer from Mr. Moret, understanding that that's not necessarily easy given the circumstances, but to say, even with understanding that there may be additional trips to truck the oil and produce water away, that this minimizes or it does not minimize. And I don't know that we got that answer today. And so based on that alone, I will say that it makes it difficult in my belief to say one way or another whether this application adequately minimizes those impacts to wildlife resources, given that they cannot avoid the impacts to the wildlife resources. I do want to say that just in response to one thing that Commissioner Messner mentioned, talking about the alternative location analysis, I agree. The point of the alternative location analysis is not to say is not to focus on economics, is not to focus on the feasibility, the technical feasibility. However, it doesn't say that that can't be taken into effect as to why the operator ultimately chooses the location they choose. Ultimately, our job as a commission is to look at the application presented to us. The operator can look at 15 different sites. It can look at 3 different sites if it has to do an ALA. And if they say, this is the site we choose to go forward with, our job is not to say, we like this site better, we like this one. It's to say, does the location that's being proposed in the application meet our rules? Does it adequately protect public health, safety, welfare, environment, and wildlife resources? And so in response to Commissioner Messner's comment that there was no showing in the alternative location analysis that the location chosen avoids impacts to wildlife resources, again, I just want to say, I don't think that's possible. Because as Commissioner Messner mentioned, it specifically talks about to avoid adverse impacts, you have to, quote, not cause quantifiable direct, indirect, or cumulative adverse impacts. And as Commissioner Messner mentioned, an indirect impact would be habitat fragmentation. And so while there is no choice but to be in high priority habitat, and again, in numerous high priority habitats, there's not a way to avoid that habitat fragmentation. There's not a way to avoid those quantifiable impacts. And I think it's important to know that while you avoid, minimize, and then mitigate, it's also important to understand that it can't be just avoid or you're done. Otherwise, the meaning within the words provided in the legislation are not given meaning if it's avoid or nothing's done. And so when it cannot be avoided, as Commissioner Messner mentioned, the unavoidable adverse impacts, you have to look to minimize and mitigate. And again, I'm not sure that that's done. I thought coming into today, reading through the application, that it was, but based on the testimony today, I don't know that I have that answer. And so just based on that alone, I'll kind of leave it as it is, that I'm not sure. I'm not sure how I feel about the application, because there seems to be some confusion about whether it adequately minimizes based on our experts and our sister agency, CPW.
Thank you, Commissioner Cross. I'll go next. I will not be nearly as eloquent as my fellow commissioners, but just cutting to the chase, I think that the conundrum of there not being pipelines and the fact that the oil and gas will be trucked for the lifetime of the well, that this does not avoid when you're in the middle of an important habitat. I agree with Commissioner Cross that we approve, disapprove, or conditionally approve the proposed location. I do think the ALA can help inform that decision. And here I find that the ALA could find locations where perhaps some, but not all of the mineral estate could have been developed. Waste in the act now is not the failure to get all the resource if it's necessary, if an alternative is necessary to be protective of wildlife resources. I find that to be the case in this application. The CPW official, Mr. Moretz, seemed to be getting more on the not approvable side versus the approvable side when he was faced with the one truck maintenance visit compared to the potential of 15 to 90 trucks. I would like, having said that, I'm not in a position to approve this application today. I would like to provide the incentive to the operator to induce the development of pipelines in this area. And in that regard, I would indicate that if pipelines were available or were to be used or were to be developed, I believe this becomes an approvable application. Final deliberative thoughts for folks, Commissioner McGowan?
Thank you, Mr. Chair. And I think that all my fellow commissioners have said some insightful things. The only pieces I guess that I would add is we also have to look at the reasonableness and necessariness of things. And when something simply isn't available for the operator, we have to be able to take that into account. And we've done that before in other deliberations. And I think it's fair for this operator for us to look at whether or not piping is available. And I think that they've shown some good faith effort to try to figure out how to make that happen. For me, the bigger conflict is trying to decide what this impact is to wildlife and whether or not they've met their burden to show that they're avoiding, minimizing, mitigating. I feel a little bit like we have competing interests based on conversations with Mr. Moret, right? So if we place this in the middle of a section, we are dividing up important habitat, and that is not a preferred location. If we do two separate locations that are nearer to the 400-meter buffer near roads, we're now increasing the density of locations and wells, which now changes future assessments of oil and gas operations because we're increasing density. And I think that puts CPW in a conundrum. I don't think that Mr. Moret and maybe even this commission had a full understanding of the proposal and the number of occupations and what that means for truck traffic. I do think that the estimate of truck traffic is on the high side because they did the estimation as if they were doing all 16 wells at once. And I don't think they've been clear that's not what they're doing here. I think that I don't think it's the 90 truck trips per day. I guess I would have appreciated maybe a further conversation with CPW to figure out if shrinking the number of tanks, shrinking the footprint, and then shrinking therefore the number of truck traffics might have been more palatable. But I think Mr. Moret was under the impression that there was only going to be one trip per day. So that puts us at another kind of conundrum. So I just don't feel like I have enough information to say that I think that this meets all of our rules and what we need to see that's protective of wildlife. And so for those reasons, I'm not comfortable voting to approve it. I do think that there could be work done to change the outcome for this application if the operator wants to think about working on it a little bit with CPW.
Thank you for those deliberative thoughts. I believe we've stated on the record the areas of concern, et cetera. I do want to sort of repeat for the applicant that if it's helpful that you've heard from commissioners that pipelines, if they become effective, make this area more developable, I hope that's a takeaway that you can work with. I know you've done a lot of work to date, and maybe you've exhausted all the work that you can do. But I did want to make that on the record. With that, Mr. Bradley, did you want to say something?
Yeah, can you hear me okay, Director?
I can.
And I appreciate the deliberation and the points brought up. We've been kind of multitasking here and kicking around other ideas. One that came up is like, what if we lay a pipeline to one of our other locations? But the reality is that the other locations are in the same HPH area, and that product ultimately has to be trucked off. So it really doesn't change the fundamental fact that the product has to be piped off here. And just for the record, we have been clear and transparent about that through the submittal process and our paperwork in the WOGLA. I was just looking through the transportation plan associated with the WOGLA. So No, I understand that that has been a bit of a wrinkle in this. However, we've been clear on the record and through our submittals of what that truck traffic would be. And we can't come up with a way to avoid it, Chair. All we can do is make a commitment that if that option becomes available, we will connect. And if the commission wanted to, you know, assign that as a COA, that if liquid takeaway becomes available, we will connect, we would accept that as a COA. But, you know, simply taking more time to talk about the same reality isn't going to change the outcome. And I apologize, but that's the reality.
No, I understand.
If I may, I'd just add, you know, that interplay between midstream and upstream, it's a chicken or the egg, and inducing another company to outlay, call it $1 million a mile before there's any production, this day and age just hasn't proven to be possible. Best I could say is we continue to echo what Sam said and continue to attempt that. COA would be acceptable, of course. And as Commissioner Cross pointed out, that there's HPH all over this whole location. Did attempt to position this away from other points. I know we continue to come back to the pronghorn, but that aquatic native species 500 feet away, or the invisible wall that we've been informed about between DSU 10 and the east. And I recognize the technical feasibility argument has been removed from the rules. But again, to Commissioner Cross's point, it still plays in an operator's mind for their decision where to drill. And we attempted 3 sections from one surface location in an attempt to minimize that disturbance throughout this area because of HPH.
Okay, well, I appreciate the final thoughts. You know, I think that we're all put into a difficult decision-making spot. And I think that having heard from my fellow commissioners, I think they have done a very good job of articulating the competing interests that exist within the act and within our rules. And I think that I'm not in support of a condition that if a pipeline happens to be there, then you're going to use it, because that means the counter exists, that if the pipeline doesn't exist, then you can truck forever from these sites. My point is if it helps in terms of providing incentive for pipeline development in the area for folks to know that this commission thinks that the use of pipelines is a mitigating and avoiding factor in terms of wildlife, then that's the message I wanted to send. That may not make a hill of a bean's worth of a difference in the financing community, but it's worth my saying it. So with that, I would look for a motion from a fellow commissioner, or I'm happy to make a motion. Commissioner Ackerman.
Thank you, Mr. Chair. And again, I appreciate all of the discussion here today. This is indeed a difficult issue. I think one of the key points is that the concepts of avoid and waste do help us understand that in some cases, post Senate Bill 181, development may not be timely or appropriate in certain sensitive locations. I think that the middle of sections in pronghorn winter concentration areas is among these locations, and I would make a motion to deny this application.
Second. We have a motion and a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed?
Aye. I
Aye.
think it should be stayed. I'm just letting you know why I'm voting aye for nay.
Wait a minute, I'm sorry. What is your vote, Commissioner McGowan?
I'm opposed, but I'm opposed because I think it should be stayed.
Okay, so we've got 4 votes to deny and 1 vote to not approve the motion with the basis being.
I'd also vote to not approve the motion for the same reasons as Commissioner McGowan.
Okay, so counting the votes, we've got 3 votes to approve the motion, which is to deny the application. We've got 2 votes to not approve the motion. The basis of that is that it should be stayed. Very good. We've concluded the business of the agenda today. I look for a motion to adjourn.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? We're adjourned. Thanks for working hard today, everybody.